Ja, sehr gut. Ja. Good afternoon, ladies and gentlemen, and welcome to our conference. A warm welcome from Rainer Schulze, Dirk Stadelmeier, and myself to this conference on the value of consumer data in the digital economy. We are really glad to welcome distinguished experts from all over Europe, and consumer data are called the new oil of the digital economy. Perhaps they are better the new sun of the digital economy because they are renewable energy. And as you know, in this very street in 1503, Copernicus had his second university degree. So somehow we are discussing a new constellation and how to regulate this issue. I am particularly glad. I owe a special thank to Rainer Schulze and Dirk Stadelmeier for having, would say, delivered a fundamental contribution for the concept of this conference, which aims also at serving the future of European data law, of European contract law. Indeed, it's not by chance that our roundtable at the end of the conference will deal with the question, should the EU regulate the fair share of consumers in the use of their data? And we aim, therefore, at serving the future of the European regulation in this field, and so that it shall be a very constructive conference, and with this perspective we are glad to count on, would say, some of the top experts in this field. So the schedule is quite tight, and having thanked my two core organizers and the distinguished speakers, I would also like to thank the audience for being here, and I hope we will count on a lively exchange, on lively discussions which will shape the contours and the content of the regulation in this field. Thank you very much again, and I give the floor to Rainer Schulze.
Thank you, ladies and gentlemen, dear friends and colleagues here in the hall and on the screens. It is a special pleasure for me to come together with you at this conference. I'm delighted that with the value of consumer data in the digital economy, we are turning our attention to a topic of immense importance for consumers and entrepreneurs alike, for politics, business and law, for legislation, jurisdiction and jurisprudence. I would like to thank you all for your participation as speakers, panelists, discussants and listeners. My sincere thanks also go to the University of Ferrara for making this meeting possible and for providing us with an unrivaled setting. I'm not only referring to the external setting, the marvelous buildings, the splendid premises, the impressive atmosphere of this university rich in tradition. I'm also referring to the scientific framework in which our conference is being held. I was already impressed by the university's focus on cross-border issues when I first came here, almost 3 decades ago, for an international conference, organized by the unforgettable Grand Master of Civil Law in Ferrara, Giorgio Chan, on the topic I 100 anni del codice civile tedesco in Germania e nella cultura giuridica italiana, an Italian conference on a German legislation with a European perspective. In recent years, this university has once again taken on a pioneering role in the discussions of cross-border issues. Now, with regard to the new challenges for law in Europe posed by digitization. This is demonstrated by some widely regarded publications such as the volumes on European contract law and the digital single market, edited by Alberto De Franceschi, and on the digital revolution, challenges for law in 2020. This focus on the tasks facing law in the digital age now continues with our conference. Allow me to begin my introductory remarks by very briefly emphasizing the general aim of this conference before I say a few words about the choice of theme and of some focal points of this conference. As for the aim, my co-organizers Alberto De Franceschi and Dirk Stordenmeier and I, we want to create a forum for exploring new legal ground with this conference and perhaps with subsequent conferences. We are inspired by the common experience of previous conferences on the challenges of digitalization for the law, in particular the series of the Münster Colloquia on EU law and the digital economy, and the events of the European Law Institute and the Special Interest Group. In complement to these, we would like to open up an additional space to think ahead about what is not yet or only inadequately covered by current law and what has not yet even taken shape as a proposal by the European Commission, but which may need to be put on the agenda of the European and national legislation in view of the challenges posed by digitalization. Thinking ahead, in this sense, is always a risk. It includes the courage to take unknown paths and also to be provocative and to make fruitful mistakes. We should therefore see our conference as a place for intellectual experimentation, as a venue for presenting and discussing hypotheses for legal developments in the digital age without shying away from unusual approaches and unfamiliar roads. With this in mind, we have chosen the value of consumer data as a theme for our meeting today and tomorrow. You can often hear and read that data is the oil of the digital economy, as we heard 10 minutes ago, that data is of equal or greater value to industry than raw materials, that access to data and the processing of data are crucial for adding value to enterprises, and so on. However, such statements are easier to make than a precise determination of the actual value of data in general or the specific economic transaction. Nevertheless, this determination of the value of data is by no means irrelevant, neither for participants in economic activity nor for lawyers. This applies just as much to personal data and to consumer data as it does to non-personal and to business data. As far as the economic relevance of consumer data is concerned, both the enormous scale of its value in the digital economy and the methodological difficulties in determining this value precisely can be seen in a number of recent investigations, such as the OECD digital economic papers on exploring the economics of personal data, or for example, the study from 2017 commissioned by the Expert Council for Consumer Affairs at the German Federal Ministry of Justice and Consumer Protection. I will limit myself here at this moment to mentioning three figures which, with regard to the order of magnitude of the economic value of data, and in particular of personal data, that is already evident from such studies. The annual economic benefit of data in Europe has been estimated at approximately 3,300 million euros in 2020. More than 90% of the revenue of companies such as Facebook and Google has come from advertising based on the exploitation of personal data. And an average revenue per user per year worth around 20 euro has been calculated for Facebook and around 40 euro for Google in 2020. From a legal perspective, the value of consumer data is a cross-cutting issue. that affects several areas of law. At the European level, it forms the open flank, so to speak, of legislation that is growing dynamically on the basis of the digital single market strategy, right up to the recent Data Act. In particular, the Digital Content Directive of 2019 has emphasized the importance of data as counter-performance in consumer contracts. However, none of these legislative measures answer the related questions about the criteria and methods for determining the value of data. With regard to consumer data, these questions relate firstly, but not exclusively, to consumer law. What is the value of the counter-performance that consumers provide in the form of personal data in contracts under Article 3 of the Digital Content Directive? Consumers can only uphold their interest in this respect if they are aware that their provision of data has a value, and if they have an idea of the size of this value. Obviously, in the framework of the digital economy, the model of the informed, empowered consumer requires consumers to be informed about the value of their data. This problem arises not only within the scope of the Digital Content Directive, but also for all other contracts, sales and services, if the consumer provides the trader with data as counter-performance in addition to or instead of the monetary payment. However, this does not only affect consumer law. Rather, the question of the value of consumer data also arises in B2B legal relationships, insofar as companies conclude contracts with each other about consumer data, in particular about their resale and their processing. In this respect, the question of the value of consumer data is also an issue with relevance for commercial law, and sometimes also with relevance for competition law, if, for example, individual companies dominate the market for trading in certain types of consumer data and for their processing. Using the traditional categories for classifying civil law matters, the question of the value of consumer data can affect various core areas of the law of obligations in particular. This includes not only contract law, as already mentioned, sales contracts and service contracts, but also the area, for example, of unjust enrichment. For example, in cases of failed contracts, when consumers or traders demand reimbursement of the value of personal data provided by them and used by the other party. In these cases, the issue arises as to whether the value of data is a restitutable object under the law of unjust enrichment, and if so, how this value is to be assessed. Furthermore, the question of the value of consumer data can also be posed for the classic law of tort or responsabilité civile, in addition to the GDPC rules, if, for example, a company obtains such data from the consumers themselves or from another company by an unauthorized action, or if a hacker destroys such data. To conclude our journey through the legal landscape, it remains to mention procedural law. This legal matter is of particular importance for our topic because consumers are unlikely to assert the value of their data individually in court. Prices that are not calculated transparently with regard to the personal data provided, even data obtained by misleading the consumer, etc. All this might generally not be worth the effort of a lawsuit for the individual consumer from a rational economic point of view, in face of the small amounts in dispute in each individual case. The procedural possibilities of collective judicial enforcement and the possibilities for associations to take legal actions are therefore decisive for the realization of the value of consumer data in the event of a dispute. In this context, it is particularly worth to consider which methods and procedures, not limited to individual cases, can be used to analyze the value of data, for example, discussing approaches such as the aforementioned calculation of the average revenue per user and per year of data processing companies. Against this background, we have chosen three main topics for our conference. Firstly, we will take a look at the general framework of trade and data, and in particular at the tension between data as an object of trade on the one hand and as an object of personal rights on the other. As this had led to lively controversy, especially in respect of the Digital Content Directive. We also want to have a look beyond these discussions on EU law and perhaps enrich them by considering common law perspectives on the value of consumer data. On this basis, the second section of our conference will then go into more detail on the central issues of the monetization of consumer data, including the protective instruments that become necessary due to this monetization. For example, what types of contracts are used to monetize consumer data and what consequences does this monetization have for the contract structure? As far as the protective instruments are concerned, in what way can information obligations make consumer aware of the value of their data and how they can realize this value without being rendered ineffective by the often lamented information overskill? Is it appropriate to provide for price control in relation to general terms and conditions with regard to the fair consideration of the value of consumer data and pricing? Should we therefore restrict the principle that main performance obligations are exempt from the control of general terms in preference to this type of price control and thus move closer to the idea of justum pretium? To put it bluntly, should we weaken the liberal features of contract law in favor of an idea from the tradition of canon law, which is now being transferred to consumer law, the justum pretium? Finally, tomorrow, the third section will deal with approaches to determining the value of data. Embedded in the overarching topic of the economic dimension of personal rights and the boundary to non-tradable assets, one of the basic questions to be asked is to what extent market mechanisms can and should determine the value of personal data and what reactions to market failure are appropriate. It will also be necessary to analyze which individual factors are decisive for the value of data in the B2C sector and in the B2B sector. That is, the role, for example, of the respective source of the data, the quality of the data, type of data, as well as the creation of value through the collection and the possession of the data, etc. From a lawyer's perspective, these considerations serve to evaluate legal issues in all the areas of law already mentioned. However, this evaluation must combine both normative assessment and economic analysis. In other words, law and economics. The third section therefore brings together the expertise of legal scholars and economists under a common theme. At the end of our conference, before Alberto Di Franceschi presents the conclusions tomorrow noon, a round table will analyze the discussions of both days under the question, should the EU regulate the fair share of consumers in the use of data? This roundtable will focus on future legislative practice by addressing the legislative tasks that arise as a consequence of the topics and ideas we will consider today and tomorrow. Ladies and gentlemen, dear friends and colleagues, I look forward to our discussions on these topics with great excitement. The floor is open to explore a new field of private law in the digital economy and perhaps provide inspiration for future European Union legislation. Thank you for your interest in these tasks and for your patience with my introductory remarks.
Hello. There's some glasses. All right. Good afternoon. My name is Andre Jansen. I'm a professor at Radboud University in Nijmegen. Alberto, grazie per l'invito. È sempre un piacere essere qui. Grazie, di cuore. I have the privilege to moderate the first panel. First panel is titled Trading Consumer Data Background and General Framework, and maybe a very little story as we have a little bit of time. In November, I was in China, and I had to, in Beijing, and there was a conference on AI and private law, and I gave a talk there, but they were not so much interested in what I said, but they were interested in data. Everything was data transfer. Whatever we wanted to say, and there was a group of Germans, and we were talking about AI and AI liability, and they said, no, let's go back to data. Let's go back to data transfer. So it was just, after a while, we were like very puzzled, and everything was data transfer. And they also gave us a tour at the headquarters of TikTok, and no surprise, everything was data transfer. It was the absolute hot topic. In China, well, that's not very surprising, but to the extent, was even surprising for me. And we should have that in mind. And without further ado, I would like to introduce the first speaker, that's Andreas Sattler, to the left. And he is a deputy professor right now at the Karlsruhe Institute of Technology. He did his PhD in Bayreuth and his habilitation. So in Germany, you have to write another PhD because the system has been invented by the devil himself. An American colleague once told me, you have to write a second PhD, the habilitation, and you did that at the LMU, so in Munich. And he is, if you see his CV and his list of publications, so if you have any questions regarding data, that's the person you have to ask. And Andreas' title is Personal Data as Object of Trade, Opinions and Limitations under the GDPR. Andreas, the floor is yours.
Yeah, thank you very much for that kind introduction, and thank you very much indeed for inviting me and having me here to present at Ferrara University. It's a real honor. So I wonder whether the Chinese students and people, when you met or went to a conference, would also be interested in the GDPR. I'm not so sure, but maybe the GDPR is something that spoils data transfers. We will see whether it does or not in the European Union to some degree. So I will look at the personal data. Of course, consumer data and personal data does not necessarily mean it's the same, but in many aspects, usually consumer data, at least if it can be traced back to one natural person, one consumer, will be personal data at the same time. So therefore, in many aspects, if we talk about trading consumer data, evaluating consumer data, it's often about the personal link to a natural person that is identified by this data. So let me just give you a short overview of my agenda. I'll give an introduction. I can be really short on this one because we already had an introduction which mentioned most important points. I will then take a look at the options. So how can consumer data be transferred or traded? And then I will take a look at the limitations necessarily or mainly provided by the GDPR. And from that I will draw some conclusions which hopefully will help us in the next 2 days to sometimes come back to this conclusion or ask ourselves, would that work under the GDPR, or how does that work under the GDPR if that consumer data is personal data as well? So as Dirk Schulze already said, I mean, it all started for the lawyers, the discussion, when in Article 3 of the Digital Content Directive, it said that the Digital Content Directive should be applicable if a consumer does not provide monetary or currency as counter-performance, but personal data instead. It didn't say whether that's legal, illegal, how that works. It was just the idea that the scope of this directive should be applicable. So it didn't, give us any hint whether that's a good thing, a bad thing, whether we should accept, whether we should legally support it or not. That's reality, actually. And if that's reality, we should put it in there when we talk about the scope of this directive, because consumers who don't provide money, but personal data instead, should have the same rights and the same protection as those who pay in money. Now that's when the discussion started, mainly under the focus as personal data as counter-performance. But of course, especially with the Data Act now at least, it opens up and it's clear that personal data as consumer data is not only interesting if it is counter-performance, but it can be actually the main topic of some contracts. If we talk about data transfer contracts, then it's not about counter-performance, it's about having personal data as an object of trade. So my presentation will always take a look at the Data Act, which is the latest European rules on trading personal data, so to speak, because once again, Article 1 of the Data Act now tells us that this regulation covers personal as well as non-personal data, so it makes no difference. It says all personal data is again within the scope of this European law. And of course, data protection supervisors will get nervous or are already nervous when they read this sentence, and then there arises the question, what does that mean when we look at Article 3 of the Data Act, which says actually that the manufacturers of connected products, so all that we're talking about, smart products, the industry of things products, they shall be designed by the manufacturers in a way so that the user of these devices has an easy and direct access to the data generated by these connected products and related services. Now then, of course, you can call that accessibility by design, to put it short, and it should be designed in such a manner. But that is at some tension with the GDPR that has the principle of privacy by design. I wouldn't say that accessibility and privacy cannot be reconciled with each other, but nevertheless it's quite clear that there is some tension between these two different principles. Of course, a tension that the European Data Protection Board and the European Data Protection Supervisor were right on aware of, and therefore in their criticism of the first proposal of the EU Commission of the Data Act said, well, we see a risk that the DA with its intention will have some tension with the GDPR, especially the principle of data minimization, which is in the GDPR, and probably also, it's not in here, but probably also with the principle of a specific purpose, so purpose limitation. What are you going to use that personal data for? I mean, the Data Act wants to open up data silos and wants to have different participants to use that data in order to invent or have any innovation based on that data, but that of course is not the idea of the GDPR in general. So we will have a tension, and it's an obvious tension. If you look at the recitals, I didn't go into the details now for this presentation, but all this criticism was actually accepted and was at least taken seriously and was put into the recitals, so to make sure that the GDPR prevails. That's not only in the recitals, it's in Article 1, paragraph 5, where it says whenever there's a conflict between the GDPR and the DA, the GDPR should prevail. Whether that works, we'll see, or how it works. As a last slide for the introduction, but that's not my topic, it's the topic of Teresa, I think, more, and Martin Schmidt-Kessel later on, is the question, well, if we look at the GDPR, what does that mean for contract law to some degree? I'm not going into details. But because we're talking about personality rights, it's probably quite difficult to have something like a real transfer or a real sale of personal data, where I'm not saying it's property, just you have the idea of property where something passes on to someone else and one person loses control over this object and the other gains control over this object, exclusively or not exclusively, but nevertheless I think something like a real sale in our traditional sense is probably not possible in the EU when it comes to personal data. But as I said, it's not really my topic. So what we're talking about also under the Data Act is more rights to access, use, and share personal data, because that's what the DA in its Article 4 and 5 is at the core of the DA, so to speak. So looking at that access, use, and sharing, and coming from the background of saying personal data is probably something that is close to personality rights, what we might be talking about is more like lease contracts maybe, or what an IP lawyer would simply say as an excuse to some degree, it could be something like a license. license. I know you don't like it, but that's the abstract way of saying it's similar to a license. It might be worth looking at license contracts and what's said in license contracts about copyright law or personality laws, rights that we had even before we had personal data. It's not a license, it doesn't say it's a license, it's just that we should compare it, because it gives us a hint of what at least should be in a contract that also concerns personal data as an object of trade. So trade is possible, to put it short, but not a transfer, in my opinion. And of course, there are other services that are based on personal data, but then it's maybe not so much about who gets access, use, and sharing that data for their own purposes, which might be a data recipient, for example, but it's more that a consumer might have bought a smart product, and the product is only smart if the provider is allowed to use personal data to make it smart, in order to have things, apps, applications personalized so that the consumer has a product that is actually fits his interests. We're not talking about advertising now, but really apps that have been personalized. And then it's not so much about using that data for other purposes. That might happen as well, but that's something that's actually necessary maybe to provide a certain service to a consumer. So far through the introduction. Now, if that's the introduction and what we're looking at, my challenge is, now how does that, what happens out there, fit under the GDPR, and can it be reconciled with the GDPR? So the first challenge is, which legal basis under the GDPR, if the GDPR prevails in any conflict, or should prevail over the Data Act when it comes to personal data, which basis is available? So Article 4, that's the right of access and use for the user of a connected product or related service towards the data holder. That's the person that has the factual control, let's say, of the data that has been generated by this device. Let's call it smart device. And it says if that user is actually not a data subject, so probably not even a natural person, maybe a company, a legal person, whatever, but not the data subject itself, according to the GDPR, then that user can only, or the data holder should make that data only available to such a user, so perform his duty under Article 4 towards the user, if the user, or if there is, usually it will be the user that has to prove it, has a valid legal basis for processing that personal data as far as personal data is concerned. So the DA just links itself towards the GDPR and says, look into Article 6 of the GDPR, that's where all the legal bases are. Look to Article 9 GDPR, that's where the basis is if there is a special category of personal data, so sensitive data about sexual orientation, religious interests, or religious beliefs, or being a member of a workers' union or a political party or something like that, which is considered to be more sensitive data. And the same counts for Article 5. So that's the right of the user to share the data. I'm not saying to transfer, but let's say to share the data with another data recipient, so a third party. Again, there has to be, so probably the user will be the person that has to prove it, a legal basis for opening access to another third party to that personal data. So what the DA does is point towards GDPR. So if we are looking at a legal or for a legal basis for all those data accessing, using and sharing under the Data Act, it will be the GDPR that decides, in my opinion, but that's often open for discussion still, I think. And what makes that even more clear is Recital 7, that once again says that this regulation, so the DA, does not constitute a legal basis for processing personal data. And it doesn't impose any obligation on the data holder to process personal data if there is no legal valid basis under the GDPR, at least that's my understanding of it. And it also says again in sentence 10 that it does not create a legal basis and does not confer any new rights to the data holder to use or process personal data generated by that connected product or the related services. So in my opinion, everything in the DA actually points at the GDPR and doesn't provide an own legal basis for these access, use and sharing rights when it comes to personal data. So that brings me to the starting point in the GDPR. The GDPR in Article 6, let's say, has 5 possible legal basis for processing personal data, even within the scope of the DA. Now, if Article 4 that I just showed and Article 5 of the DA do not constitute a legal basis themselves, as Recital 7 says, then I think we cannot use Article 6, Para 1c C and para 1E of the GDPR. That's where the red minus symbol is. Because these are rules in the GDPR that say, well, if there is somewhere else a statutory provision in national or union law that allows for the processing of personal data, that might be sufficient, or that is sufficient under the GDPR as well. But if the DA itself says, hello, me, the DA, I don't constitute any legal basis, then I would think I should not use Article 6C and not Article 6 para 1 literature E, which has the public interest as one reason for processing personal data, and they are not applicable within the scope of the DA. They won't help us when it comes to any rights under the DA that concern personal data. Of course, you could argue that, you know, it's in the public interest to open up data silos, and therefore literature E would apply, because companies that have innovation are, you know, serving the public interest, but I think that goes too far, of course. I mean, someone might, you know, I think someone has written it, but it goes too far in my opinion. Anyway, so what is left is actually the consent, which is 6 para 1 literature A, and when it comes to sensitive data, Article 9 of the GDPR, which is generally left as contract. So if processing of personal data is necessary in order to provide the performance under a contract, it could be justified under Article 6 literature B. And also the vague, or let's say broad general clause, which is litera F, the last one, where it says, well, the controller under the Data Act has to balance the interests, and if the interests of the data subject do not prevail, are not to a high degree, then the controller might use that personal data or process it. So those three are left. Are they all left? We might go back to the Data Act and question whether the Data Act might exclude one of those three, so consent, contract, and balancing of interests. And when we look into recital 34, once again, it refers to Article 6 GDPR and says a legal basis for the processing could be something such as the consent of the data subject or the performance of a contract to which the data subject is a party. So this recital explicitly only refers to Article 6 para 1A, consent, and Article 6 para 1B, the contract, as far as it's necessary for the performance of contract. So we could ask, is the legitimate interest, balancing of interest, excluded under the DA because it's not mentioned in the recitals? And what might argue in that direction is that actually the recital 30 of the draft agreement didn't mention the performance of contract, which is here in green, but mentioned the legitimate interest, which is the link, or which directs at Article 6 para 1 literature F of the GDPR, the balancing of interests. But that was replaced and substituted by this reference to the contract. Now, does that tell us anything about what the legal basis of processing personal data under the DA is? I don't think so. I mean, I don't know why the legitimate interest has been crossed out and not just simply left, and the performance of a contract added as third option. That is what probably, you know, to me looks most appropriate. But as it also says in recital 34 now, in the final version, is the word such as. So it's only examples, and therefore I would think that the balancing of interest, because the Data Act only gives us 2 examples, is not excluded by the recitals, or it doesn't even give us a hint that it should be excluded. So again, all I said is one could doubt whether the literature F, the balancing of interest, is within the, or should be used within the scope of the Data Act, but I think it should, and the law doesn't say anything against it, in my opinion. Probably this stressing of the performance of a contract was based on the idea, as you might have heard, that the Data Act places the user in the center of the Data Act and wants to provide data transfer, data sharing, data use based on contracts. So I would read it rather as stressing the importance of contract in general under the Data Act, rather than saying this excludes the balancing of interests as the GDPR provides. But I don't know why it was changed in that manner, why the legitimate interest was replaced by this hint towards the performance of a contract. So that means we have these 3 options. We have 1, 2, and 5, if we look at the options available under the GDPR. And they are the usual valid legal bases available when it comes to processing personal data in a private law context. It's not only under the Data Act, but also under the Data Act. It's also in other areas of private law. I think those are the 3 most important bases for processing personal data. Now, then let's take a look at those three. And whoever is interested in the GDPR or has been or might after this conference be interested in it, I would really recommend to read this judgment by the Grand Chamber of the European Court of Justice last year. And it was a case concerning Meta, so it was a case concerning the business model of Facebook. And the fight between the German Office Against Monopolies and Meta, Facebook, on questions of competition law as well as data protection law. And here the European Court of Justice and also the Grand Chamber of the European Court of Justice said that actually Article 6, literature B to F must be interpreted restrictively. And why? It didn't give them that much of a justification, but it says because otherwise the data subject's consent will usually not be asked for, will not be obtained if we interpret the other valid bases under the GDPR in a broad manner. Then no one will actually care about the consent. No one will ask data subjects for their consent if you can easily justify what you're doing under the other legal bases of the GDPR. So first of all, there is some consent takes some primacy, if you would like, you could say. Consent goes first, and maybe, I'm not saying if consent doesn't work, you can go back to one of the others, but at least from the opinion of the European Court of Justice, consent sticks out somehow, or should be taken seriously, and not be circumvented or avoided by other possibilities under the GDPR. That's what I would take from the sentence, at least to some degree. Now, if we look at you can process personal data as far as is necessary to perform the contract, it also says that is only possible if you cannot achieve the main subject matter of the contract without processing this personal data. So you cannot just process personal data if it's some duty you have under the contract or if it makes the contract more easy to perform or whatever. It is the main subject of the contract that it has to refer to. And then secondly, it says the decisive factor will be that the processing of this personal data in order to perform your main subject matter, your main duties, you could say, of the contract, it has to be essential and there has to be no other workable, less intrusive alternatives. Now, we don't know what these less intrusive alternatives will be. The question again is consent less intrusive than actually saying, well, I use your personal data based on any contract that we have, and if I need that personal data to personalize some services towards you, I can use literature B, or is there a less intrusive alternative if I can have a consent which will be differentiated from the general terms and conditions of the contract probably, and which will be probably therefore less intrusive because the data subject will be more aware of if it consents rather than when it comes just with a contract and its performance maybe, but that can be discussed as well. Turning to the balancing of interests, so litera F, once again it sticks out that it says those must be interpreted restrictively in order to let the consent somehow prevail, so that consent takes priority, so to speak. That's the same paragraph that I had when it came to the contract. And there it said, but of course this is a case on Facebook. So it was Facebook that wanted to legitimize, let's say, or justify its business model of personalized advertising towards its users based either on the contract, user and we as users and Facebook, or base it on the legitimate interest of Facebook to finance their own business model. That was the second shot Facebook took on literature F, because they of course wanted to avoid consent actually. And here, in that context, I mean, one could say hard cases make bad law, so we're not sure whether what counts for Facebook will apply to all other business models that we might see under the Data Act, for example. But here it says a user, again, it's the same as a data subject in this case, cannot reasonably expect that the controller, in this case Facebook, will process that user's personal data without consent for the purpose of personalized advertising. So what it said here is that once you balance the processing of personal data on your legitimate interest, this legitimate interest must somehow be expectable for the user. So if it's something really out of what users would expect when concluding a contract with that controller, then it should also not fit under literature F and the balancing of interest. Then it's surprising under general terms and conditions. We could say maybe it's even surprising, but at least it's not something you would reasonably expect. Data subjects, the Grand Chamber says, would expect to be asked for consent. That's what it says. And of course it also says, well, your interests in financing your activity with personalized advertising is no legitimate interest, or at least no legitimate interest that we rank higher than the interests of the data subjects. So litera F doesn't work for Facebook, to put it short. Yeah, but what does it work for? If we apply it under the DA, we can ask us, do data subjects who are users according to the definition of the Data Act, can they reasonably expect that their personal data will be used by the data holder or a third party, let's say for AI training, not application of AI, if we can actually distinguish between the two, but just for the training of AI. Is that something that users can now, expect when they use a connected device, for example? Can they actually expect that the data holder or the manufacturer or a third party that provides me related services might be able to use their personal data to improve their own products? Is that something I don't need to consent to because I can accept that's a legitimate interest of the provider that they will, use their product and want to improve their product? Is that something that we as users, data subject, would expect that they do it, and therefore it might be a legitimate interest according to literature F? I don't know. Open question, but that could be, where the DA could work with the literature F and the balancing of interests. So in the end, we will probably, in many cases, come back to consent. People don't like consent. They all say their data subjects are never informed. They never read it. They just click. It's like the cookie banners. You simply accept it. So it's not really a conscious decision or even a decision at all. It's just clicking away banners in order to give consent and in order to get access to something. But when it came to consent, the Grand Chamber of the European Court of Justice said something that is really also interesting under the Data Act, because it says whenever we have a set of data that contains both sensitive data and non-sensitive but still personal data, the processing must be regarded as prohibited unless Article 9, one of the valid legal basis under Article 9, that's the special legal basis for sensitive data, applies or allows for it. And this applies irrespectively of whether the controller, or in maybe the case of the Data Act, whether the data holder actually wants to generate sensitive data, irrespective of whether that sensitive data is correct or incorrect, and whether irrespective of the data holder having the aim to collect such data. So what does that mean in the end? That means in the end, under the Data Act, that in most cases, because it's the user that uses a device, decides what he or she uses the device for, will determine whether it's sensitive data that the data holder automatically generates or whether it's simply personal data. So a data holder, in my opinion, can hardly ever be sure whether the data he generates is sensitive data or simply personal data. What's the difference? Well, once you have sensitive data, and even if it's only a few items of sensitive data within a bigger data set, means consent is actually all that's left for you, because balancing of interests doesn't work with sensitive data, and literature B, performance of a contract, doesn't work if there is sensitive data included in such a data set. So in my opinion, in most cases, if data holders want to be on the safe side, need consent. So the first conclusions are, whether or not the generated data under the Data Act by connected products and related services is personal or not is something that the data subject decides. And it doesn't decide that, deliberately. It depends on what it does with the device and what it uses it for. Second, separating personal data and non-personal data is hardly feasible if it's the natural person, the consumer, the employees who use a connected device. So the data holder will have difficulties in, splitting up personal data from non-personal data. And even further though, data holders will have big issues or won't be able to separate sensitive personal data from just personal data once it's automatically generated and generated by the behavior of how this device is used by the user who is a data subject. So in the end, to put it short, I think the success of the DA as far as personal data is concerned, entirely depends on efficient and effective consent management systems. If we don't implement them, if they don't work, the Data Act won't work as far as personal data is concerned. We might have other issues with just business data that doesn't include personal data, but I think we will have to have efficient consent management systems. That brings me to my second point and the limitation. Well, what's the challenge then? If you agree, or maybe you don't agree, but if it is the consent that is most important under the DA and in other aspects as well when it comes to trading personal data, what are the main topics that we face and challenges? Now, the DA in its recital 33 already mentioned PIMS, so personal information management systems. So I think the DA or the European legislature has seen the importance of PIMS to some degree. There's not much of it in the DA, but it has seen that when it comes to many users that have to be approached in order to get access to aggregated data or huge amounts of data, it will in the end probably be intermediaries as far as maybe business data is concerned, but when it comes to personal data, probably information management systems that help to manage, in the end, consent probably according to the GDPR. So if we take a look at it under the DA, we have these, to put it simple, we have these three persons. We have the user. The user is the person that uses a connected device and the related services. We have the data holder. That's the person that has the actual access to the right, that holds control of the device that generates that data. And we have the data recipient, here data recipient number one, because it can be a multitude of data recipients. The idea under the DA is that many people or many companies get access to data, so there could be 100 data recipients in the end. But we take just the example of the first data recipient. So if the user is at the same time the data subject, which is not always the case, then it's quite easy because the user can consent, or even if the user uses his right to access according to Article 4 under the DA, you could argue that with his right to access the data, he gives his consent to the data holder to make it available to him or to make it available to the data recipient. If a user asks the data holder, please pass on all the data generated by the device I use to data recipient XY, then this can be seen as an implied consent to process that data and give it to the third party. Now, trouble is, of course, that users are sometimes only controllers and are not the data subject themselves. The Data Act puts that in most of the articles. The Data Act tries to distinguish between users who are at the same time data subject, but it doesn't always, even though in some cases they won't be the data subject, but the Data Act doesn't say what we do in this case. So if we have a user who is a controller under the GDPR, meaning he processes or she processes data of other subjects, then this user will have to have the consent of all data subjects concerned, and will then have to have that consent for all the different purposes that I put here. Again, a multitude of purposes for what the personal data might be aggregated, analyzed, and used later on. And that's where I think we will have to have some either data intermediaries or more or less personal information management systems that make it much easier than it is now to have to obtain consent by the data subjects and to manage that consent, because of course, as consent can always be withdrawn at any time without giving a reason, we have to somehow implement this withdrawing of consent as well. And again, we need technical measures to support that right to withdraw consent. So if we look at consent and how can we put that into PIMS, then of course further questions arise. So I'm only posing questions today, no answers for you or for us yet. So the question is, if we have PIMS, then it's usually the data subjects themselves that click some consents. But if we get the idea of data intermediaries in between, so someone who consents in the interest of the data subject, we have to ask the question, well, can someone else consent on my behalf Is that possible under the GDPR? I'm not so sure. I mean, there are some articles that say parents have to give consent for their children, and we also in Article 80 GDPR, we have the possibility that consumer protection clubs can actually enforce the right of individual data subjects. So there is some idea of representation within the GDPR, but whether that goes as far as someone else can consent on my behalf, based on a contract that I have with this data intermediary, I don't know yet. First question. Second, Rainer Schulze already mentioned it, is it has to be informed. Now, how far do we go when it comes to being informed? Does it mean actually informed, or is it sufficient if the controller provides sufficient information so that the data subject that wants to be informed has easy access to all the information it needs? I think we have to... No, it's the lake.
You can do it.
Okay. How informed does it have to be? Second question. Third question, well, the GDPR says we have to have specific purposes, so we can't give a broad consent. It's quite difficult to say, well, you can use my personal data, including sensitive personal data, for AI training. Let's say I would be as liberal as that, and I'm fine with it. But then, is training for AI specific enough as a purpose under the GDPR? Well, I'm quite sure data protection authorities would say it's not specific enough. But then, of course, we have the question, how specific does it have to be? Is there an option, not yet under the GDPR probably, but should we have an option where we have something like a broad consent? We have some ideas of broad consent under the Data Governance Act when it comes to data altruism. Altruism is something really positive. That's why the idea was there, well, there maybe in a positive manner, when you want to help society, it should be possible to have a rather broad consent, not so specific purposes. But I think the whole discussion will start whether we should have that in other aspects, in other contexts as well, and say, well, maybe if I say I consent to research in certain fields of cancer, is that specific enough for consent to use my sensitive personal data? I don't know. But if it's all based on consent, and the Data Act should work as far as personal data is concerned, we would probably have to discuss these 3 points, because they would probably be necessary in order to make PIMS work eventually. There I come to my conclusion. So if natural persons use connected products or related services as defined by the Data Act, these will typically generate personal data. I think that can hardly be excluded by the data holder, because it's generated automatically. So it's the user who decides what kind of data is actually automatically generated, and it will include personal data usually. It adds also that the user should have an account with the data holder in order to make sure which data does belong to which user, and that makes all data a data user wants from a data holder personal data, because I have to have a user account. So we will have personal data in many cases. As the DA leaves the legal basis of the GDPR unchanged, the interpretation and application of Article 6 and Article 9 of the GDPR will eventually decide on the success or failure as far as the DA is concerned as regards personal data, in my opinion. Because it's real behavior, how I use these connected devices and related services, it's the data subjects that eventually even determine whether the data generated is only personal data or contains sensitive personal data. And therefore the controller, according to the GDPR, which can be the data holder, the user, or data recipient under the DA, should always probably assume that data that was automatically generated contains some sensitive data, and therefore is left with consent as the only valid legal basis for processing that personal data under the GDPR. Therefore, the options to efficiently and effectively give and withdraw consent for specific purposes is crucial to turn the DA into a success as far as personal data is concerned. But the challenge is, of course, that we have to have an informed consent for specific purposes. So Article 4 and Article 5 require such complex, I'll call it cascades of consents, that these depends on the introduction of personal management or personal information management systems. We need technical support for these consents, withdrawals of consent, and otherwise I think it's difficult to see how the DA will work for personal data. That's all from me. Thank you for your attention.
Thank you very much, Andreas. I think you have drawn a very interesting picture, and I think this was a lot of food for thought. So we are continuing now with our second speaker, and then we have a discussion. And our next speaker is, yes, yeah, okay. Sì, certo. Un attimo.
Non vedo la freccia. Riesci a vederla? Eccola qua. Ok.
Hello. Hello. Good afternoon. Our next speaker is Christian Twig-Flessner. He's around for a long, long time, internationally in the field of consumer law, contract law, commercial law, and he is a professor at Warwick University. Before he was a full professor at the University of Hull. And his topic today is the value of consumer data, a common law perspective, because most of us in the room here, we have a civil law background, and even though there is a Brexit, we should not forget that we have good friends on the other side of the channel. So Christian, without further ado, the floor is yours.
Thank you and good afternoon. Can you hear me okay?
Yes, perfectly.
Wonderful, thank you. Thank you for your very kind introduction, Andre. I feel old now, seeing as I've been around for a long time, according to you. It was only a few years ago that I was a young upstart in Münster, and now I'm an old man by the sounds of it. There you go. And being an old man also explains why I can't be with you in person today. Unfortunately, my body has decided that traveling isn't a good idea right now. So I'm very, very sorry I'm not there in person, but thank you to Alberto and the team at Ferrara for allowing me to be with you, at least electronically. I am going to try and somehow share my presentation with you, which I hope you can now see on the screen.
Yes, we do.
Wonderful. So the title of my paper is The Value of Consumer Data, a Common Law Perspective. And when I talk about the common law, of course, I mean English law. And this is an interesting take on this because, as you are all aware, Andre has hinted at it, we've had a bit of upheaval in the United Kingdom in the last few years due to something stupid called Brexit. And as a result of this, the legal landscape in the UK, both in general consumer law and also with regard to data law, is already diverging quite a bit from the position in the EU. Now, because of this lack of action in many ways by the government, which is occupied with other stupid things, we are now seeing increasing gaps emerging as far as the governance and regulation of the digital economy is concerned. And there are limited efforts at the moment to play catch up. And I will talk about some of those as part of my presentation. But as you will be aware, the UK effectively stopped implementing EU consumer law imperatives as long ago as 2017, as soon as notice of its intention to withdraw had been given, and that has created a number of gaps. We do not have something that totally resembles the Digital Services Act. We don't have a Data Governance Act. And we also do not yet have something similar to the Digital Markets Act, although there is a bill getting through Parliament at the moment, but should soon be passed, the Digital Markets, Competition and Consumers Act, which will do at least some of the things that the DMA already does, albeit in a very strange British fashion. And I'm being slightly cynical, but that is actually there's actually a serious point to this, because what we are seeing at the moment is that the UK is effectively trying to invent what is already happening at the European level, but it's trying to do it in its own strange way. And if you have seen recent drafting of legislation in the UK, you will see that it is almost incomprehensible. So if you think that EU legislation is quite technical and sometimes perhaps a bit too detailed and forensic, at least there's logic to it, whereas I increasingly struggle to find logic in UK legislation. But that's just by way of background. Let me come to what I want to do this afternoon, which is to give you a kind of UK perspective, an English law perspective, on how trading in data and consumer trading in data in particular might work, with a nod to what the EU's Data Act does. Now, in his introduction, Rainer Schulze alluded to the importance of consumer data as acknowledged in the early drafts of the Digital Content and Digital Services Directive. And there is still some residual element of that, of course, in Article 3 of the DCD. The fact that consumers may provide data, access to data in return, in particular, for digital content or digital services. Now, the UK was ahead of the EU in adopting legislation on digital content, on conformity and remedies, but it explicitly restricted those rights to instances where a consumer pays for data. And that exempted, in this case, pays money effectively, and that exempted from the scope of Part 1, Chapter 3 of the Consumer Rights Act, which is the corresponding provision in UK law, the ability to recognize contracts where the consideration is only the supply of data, granting access, permitting the collection of data. There is potential to extend the reach of the Act to such contracts, but that power has not been exercised. And as I've already hinted, the UK, of course, doesn't currently have the same thing as the EU's Data Act, but there are things in the background, which I will come to a little bit later, which at least chart a direction along the lines of the Data Act, but not quite in the same way, and not with quite the same focus on connected products and the Internet of Things. I want to start by asking a few questions about how data is conceived of in English law, and whether trading in personal data or data generally is possible in English law, and if so, how? Of course, it is possible, but how do you conceptualize it? Say a few words about the regulatory context that currently exists in the UK that limits some of the ability to trade in data, and indeed for businesses to obtain customer data, and to take a look at some of the developments that might be happening in the UK and whether they're going far enough. And here we'll focus in particular on some of the provisions in the Data Protection and Digital Information Bill, which is currently before Parliament, again, very close to completing its parliamentary journey. And it is expected that both the Data Protection and Digital Information Act and the Digital Markets Competition and Consumers Act will be passed in time before the election is called. Because we are due an election in this country, and this will almost certainly produce a change in government, not a day too soon as far as I'm concerned. Okay, let me say a few words about how the common law has conceived of data, has looked at data, has thought about the role of data in the context of private law in particular. And to cut a long story short from the outset, the common law has established a general view there cannot be any property as such in information. And of course, data is a form of information. Therefore, the assumption is that there is no such thing as property in data at common law. This kind of conclusion is developed or has been kind of fleshed out through a number of cases dealing with quite specific doctrines. That's, of course, the feature of the common law, where we don't have grand statements, but rather you have to deduce certain positions from the way particular cases have been decided. One such landmark case, which acts as a bit of a block to the common law developing its approach to data and information, is the House of Lords decision in OBG and Allen, which was in fact an appeal dealing with 3 separate cases. One of the many issues in that case, which concerned various aspects of tort law, especially the so-called economic torts, was the question whether it is possible to have conversion of contractual rights. In other words, where somebody, a receiver in this case, takes over a company and modifies the contracts entered into by that company or terminates those contracts, could that give rise to a claim and conversion of the contractual rights? And the short answer was, because conversion was developed historically in relation to chattels, to tangible property, there could be no application of conversion to so-called choses in action, which are intangible personal rights, and therefore there was no ability to kind of regard these remedies to be available beyond physical products. And in developing this is the key point, in developing this, a number of the law lords, and note this was by a bare majority of 3 against 2, took the view that there isn't really a possibility to find property in data, not least because property entails something that is rivalrous, and we all know that data is non-rivalrous. It can be reproduced ad infinitum without depriving somebody of that data themselves. And this line of reasoning has been followed subsequently, for example, in your response and data team, involving the question of whether there could be a lien, some kind of possessory restriction over a customer database, so much more specifically on data and in particular personal data. The Court of Appeal observed that there may be instances when information triggers intellectual property rights, but the law has been reluctant to treat information itself as property. Therefore, information isn't property, therefore data isn't property. When information is created and recorded, there are sharp distinctions between the information itself, the physical medium on which the information is recorded. Don't forget, this is 2014, so influenced by the old distinction between tangible and intangible media. And finally, this is important, the rights to which that information gives rise. So the physical medium and the rights are separate things and can be treated as property, because legal rights can be a form of property. The information itself has never been. And this reasoning was subsequently also applied in a case called Computer Associates and the Software Incubator, which was decided in the Court of Appeal. The question was whether software was covered by the commercial agency regulations based on the EU's directive. This was one of the last references that made it to the Court of Justice during the withdrawal period, before the withdrawal agreement had been adopted and implemented. And the Supreme Court, on hearing an appeal from the Court of Appeal, which had said that computer software was not goods and therefore outside the commercial agents regulations, referred a question to the CJEU, and the court, as you all know, took the opposite view and held that software in certain circumstances is covered by the notion of goods under the Commercial Agents Directive. Unfortunately, there was no substantive follow-up judgment by the Supreme Court that unpacked this any further. The Supreme Court, in fact, simply said, because the Court of Justice has given an opposite view, that the appeal is therefore allowed, end of story. There's no reported judgment following on from this, which is slightly disappointing because the Court of Appeal had developed some quite detailed reasoning on this point, and there was a real opportunity missed here to perhaps develop some of these points at that level, at the level of the Supreme Court, and maybe revisit OBG and Allen in the course of these judgments. And this is, of course, one of the drawbacks of the common law. When it gets the opportunity, it is quite capable of developing the law to align with new business practices, to align with changes in the commercial and indeed digital environment. But if it doesn't get or doesn't take those opportunities, then of course the law cannot develop. And there have been instances time and again where the common law has failed to take up these opportunities to develop the law, to bring it back up to date, for all sorts of reasons, which are sometimes quite disappointing. And it's quite ironic, for example, now that we're seeing the Law Commission trying to put through a bill which seeks to develop the law on digital assets, slightly different from data, but in a similar direction, simply by saying that there are more than two forms of property, personal property in English law, and then handing it back to the common law to develop. How that's going to go is anybody's guess, but that's a different story. But what we can see from these cases is that whilst data itself doesn't necessarily give rise to property rights. There are rights in data, rights over data, often referred to as control rights, whether they are rights arising from the need to consent to data processing under the data protection regulation, or indeed simply the fact that you have legal or practical access controls. They are control rights, and those are rights which can be used in the context of contracts. Indeed, such rights will have some sort of value for the purposes of contract law and can therefore, for instance, be a form of consideration. Of course, you may remember English contract law doesn't care so much for equivalence of value as long as what you provide under a contract has some, even very small, economic value. So if the economic value attached to individual personal data is minute, because the real value is unlocked by having lots of data accumulated and processed, there's still some very minute economic value in this, and that suffices. Some of you may recall the slightly amusing case about Nestle and Chappell involving the value of 3 chocolate wrappers from used chocolates, from eaten chocolates. And the court said, yeah, there's economic value in those. And you've heard of peppercorn rents in English law, I'm sure, as well. You rent a house for 1 peppercorn. Crucially, the courts have acknowledged at various points in time that a person has the right to control access to data, especially personal data. They have the right to choose to whom to grant such access. And if they grant access, they can, of course, do so in return for payment. They have the right to commercially exploit access to their data, whether that's data on their devices or data elsewhere. And if there's a contractual background which has restricted the ability to use such data and that the restriction is breached, there's even a new route towards damages under a recent Supreme Court case involving the development of so-called negotiation damages, also known as the Morris-Garner principle. Again, I won't say too much about this here, but I'm sure I'll expand this in the written version of my paper. So there can be a form of trading in data, contracting for data, and you can unlock value in data. The question, of course, is how much value will be attached to this, and without any yardstick, this is purely a matter for commercial calculation. What is the consumer willing to accept? What is a business willing to pay for access to such data? And quite often, free access to digital content might already be sufficient. So contracting for data is possible in English law, but the crucial thing is that what is being contracted for is this right of access. It's not a right to gain ownership over data. It's something more limited. Now, it's important to bear in mind in which sort of regulatory context all this operates. We've heard a lot about the GDPR already in the nice comparison with the Data Act provision and some of the open questions. In the UK, there is still a version of the GDPR in operation, supported by the Data Protection Act, which at the moment is mostly the same substantively as the GDPR. So when withdrawal was completed, when Brexit was put into effect, a lot of existing regulations from the EU were transferred and became part of EU law, and now have the rather strange designation of being assimilated law. Because, of course, one of the intentions of the present administration has been to remove as many references to EU as possible. So what was once called retained EU law is now referred to as assimilated law. But the GDPR, the UK GDPR, is one such form of assimilated law. And it largely does the same thing as the familiar version in the EU, but there have already been some tweaks and some adjustments to make it slightly less burdensome. And that reflects the wider attitude of how this assimilated legislation is being dealt with. It will be modified and perhaps made less strict and amended to suit particular political interests, policy drivers, and so on. So there's going to be a gradual departure in some respects of legislation which has its origins in EU law. Now, we know about the rights under the GDPR. I don't have to go through those again. Consent to processing data portability. The question is, or has been raised in the literature, do such rights constitute property rights? Probably not, but they can probably still be traded in some other form on the basis that there is a right of access and the right to refuse consent. So there is still a possibility to have that as part of a contractual relationship. Yeah. In other words, granting consent to processing personal data in return for the provision of goods, services, or digital content can form sufficient consideration for a contract. And then we have in the background something that's often forgotten because it's sometimes simply referred to as the cookie regulation, the Privacy and Electronic Communications Regulation 2003, which are the UK's implementation of the e-privacy directive, which of course itself plans to reform it, but of course those reforms at the EU level have probably stalled a little bit. But interestingly, in Regulation 6.1, there is a requirement that a person, this could be a business, this could be an IoT business even, must not gain access to information stored in the terminal equipment of a subscriber or user. In other words, equipment that is connected to an electronic communications network, the internet. So there is a restriction on accessing information stored on the equipment. And the guidance published by the UK Information Commissioner makes it clear that this is understood as things such as apps on smartphones, tablets, smart TVs, or other devices. So therefore, software that runs an IoT device, for instance. And if there's information stored on the IoT device, which is then transmitted, that cannot be done, that access cannot be gained unless the requirements have been met, which, as you all know from the cookie scenario that was mentioned earlier, is the provision of clear and comprehensive information about why access to the information is required and the necessity for the consumer to give consent. Now, interestingly, consent has to be given in the same manner as required under what is Article 7 of the UK GDPR, that parallelism, but that's of course the same under your national law implementing the e-privacy directive. So if there is going to be trading in IoT, in connected devices generated data, that has to be done on the basis of consent provided by the user, by the subscriber in this case. There is again some kind of indication as to what might be required for effective access to data, and therefore this ability to require consent, just as it does under the GDPR, can also cover this potentially wider data, non-personal data, to the extent that it is non-personal. Of course, we've just heard it rarely is, but that can also, of course, be covered. This right to access control can also be give rise to contractual obligation. And then let me say a few words about what's coming next, because to some of you, especially those of you who've read the Data Act, this may sound slightly familiar, but not quite in the same way. In the Data Protection and Digital Information Bill, we have a particular part that deals with so-called customer and business data. And the government has presented this very much as reflecting its intention to support so-called smart data schemes. And the typical examples they give is something that allows consumers to switch suppliers of utilities or telecom services or banking services through a simple automated process. Also perhaps to enable bank account management, where one banking app can manage all of your accounts, even if they're held by different banks, and so on and so on and so on. It can cover anything and everything in theory. Now, Part 3 of the Act is quite strange because it doesn't actually contain immediately applicable provisions, but we have section after section which simply empowers the Secretary of State to develop secondary legislation. So the whole thing is an enabling part. It enables the government to adopt legislation. And the sections set out what this legislation may, in most cases, not must, but may include. And it is quite detailed what this legislation may include, but in most regards, there is no obligation to ensure that the regulations that will eventually be adopted actually do include whatever has been set out. Now, I won't go through all of these requirements because it's quite a detailed and technical piece of legislation, but I've picked out a couple of things that might be worth noting. So when we talk about customer data, first of all, we are clearly talking about information relating to a customer, which of course includes consumers, but can also include certain businesses as specified in those mysterious regulations that will eventually appear. And that information includes information about the goods, services, or digital content supplied, provided by the trader to a customer or to another person at the customer's request. And this information can cover the prices, the terms of supply, but then also crucially, how the goods, services, digital content are used by the customer. And where do you get this information from? Probably by devices collecting data and storing this and making it available, and indeed their performance or quality when used by the customer. So there's clearly something here that could link into the IoT, although it's not intended necessarily based on the background policy documents to do that. Insofar as such data can be provided, there has to be information regarding to the way this information, this customer data is provided, be given in accordance with those regulations that have yet to be made, the so-called data regulations. And it's made clear that when we talk about providing data, what we mean really is providing access to such data, given the ability to access or the ability to use such data. The data holder, a concept used in the Data Act, but defined differently here, simply a person who processes data. And then we've got all sorts of different things these regulations might include, depending on what is ultimately decided after further consultation and so on. It can, for example, it may require that a data holder has to provide the customer data to the customer themselves, or to somebody the customer has authorized. So in other words, there might be another person authorized to receive customer data. So this allows the sharing of data. This allows, for example, the customer to instruct a data holder, if it's a bank, for instance, to transfer account information to another bank, if the customer so wishes. There's also provision that may be made which allows an authorized person, in other words, somebody who has data of the customer, to take whatever action the customer could themselves take. For example, if they want to switch suppliers, somebody who's been given information about the customer can then effect the legal switch itself, can ensure the contract with the original supplier is terminated and a new contract created. So that's kind of the thinking behind some of these provisions. There are other provisions about access requests to customer data, the process by which the customer can authorize access to such data. All these things are yet to be worked out. And many other things, you can see the list is quite detailed here. And there are more things I haven't mentioned in my slides. For example, regular provision of customer data, the use and maintenance of particular facilities for data provision, enabling the data holder authorized person to produce or collect or return customer data, all sorts of things. But crucially, and this comes back to a point that my predecessor as a speaker just made, data regulation is expressed in terms that cannot authorize or require the processing of personal data where this would contravene data protection legislation. Although how this actually is going to pan out in practice remains to be seen. The underlying objective of this legislation clearly is to what might be called unlocking the value of customer data by allowing customers to get better goods and services. And whilst I think there is an argument for saying it can do very much what the Data Act does, depending on how the final data regulations in the UK are drafted, it's clearly designed for a different kind of situation. It's not designed necessarily for IoT-produced data, but it's more about allowing competition for goods or services, digital services, to increase by making it easier for customers to switch, to choose new suppliers, and so on. How it will pan out in practice, like I say, will depend on the development of these secondary regulations. So the actual implementation of these rules and their legal operation will be some time in the distance. And it will be interesting to see when these regulations are ultimately developed, or whether inspiration will be taken from the EU Data Act, even if that will be very much done in a stealth manner. You may have already seen in the Digital Markets Competition and Consumers Act, there are plans to amend the UCPD equivalent rules in the UK, and they look surprisingly like the changes made by the by the EU in 2019, even though there's not a single recognition of the fact that basically the UK government is copying out UK law. So let's bring this all together. How can consumers unlock the value of their data? It's going to boil down to contracts. It's going to boil down to making use of their access rights, their consent rights, and so on. Those rights may have to be expressly agreed to by a customer, but as far as so-called non-personal data, if they can be properly delineated, is concerned, that can of course be done through a standard term in a supplier's contract. If it comes to working out how these contracts for the supply of data might be dealt with, my guess is, in the absence of any statutory rules, we might well see some form of sui generis contract type evolving at common law. The common law is very happy to find new categories of contracts in a quite a random fashion, so there's no big objection to creating sui generis contract types where this is merited, but we can't neatly classify a contract, and that might in turn allow for the development of common law rules regarding these kinds of data access contracts, always in the absence of statutory rules. We already know that there are some limitations on how this contractual thing can work. There's the unfair terms controls under the Consumer Rights Act, and I've mentioned the UK GDPR, the DPA 2018, and of course the Privacy and Electronic Communications Regulation 2003. We will see how the new bill will ultimately develop and how it might be implemented, because that's where the real interest is going to be. How are these enabling provisions in Part 3 going to be implemented? And what we can't speculate on is how quickly this will happen. Because as I indicated at the start, there's an election due in the UK, a change in government is highly likely. If you go by today's opinion polls, even more so. And that means the trajectory of implementing some of these provisions and the timescale for this is rather unclear. So I hope that's given you a bit of a flavour. I hope I've not overrun my time too much. It's given you a bit of a flavour of where we are in the UK and what might happen in the UK. And it might offer a nice little contrast to how the EU is evolving rather more rapidly than the UK is doing. So much for our global Britain leading the data economy. Thank you.
Thank you very much, Christian, for giving us a UK flavor. And I would like to open the floor now for discussions. I don't know whether do we have a microphone? Yes, which is movable. Yes. So please, there's Dirk Staudenmeier. Maybe you can kick off.
Thanks a lot. I have two questions, actually one to Christian and one to Andreas Sattler, but actually this is the same question, if I may say so, but I pick on something which you said, Christian, from under English law, but the general question is the one which has been raised by Andreas Sattler. So if I start by with Christian, but feel free to answer the more general question, Christian, also under the GDPR. So basically the question is, you said at a given moment, could rights under the GDPR nevertheless be traded in some other form? Yeah. Now, my question is basically, therefore, could the data subject, now be it under UK data protection law or in your opinion also under the GDPR, agree in advance to renounce to withdrawing consent? Because that is a key question for me, basically. And it's interesting for managing PIMS, and it's interesting for other solutions. So if you manage contracts via smart contracts, for instance, you have your data in the blockchain. And it would only make sense if the other party knows that the data subject not at any moment can decide, oops, I've changed my mind. So the economic basis of the contract is strongly weakened, at least. So that's the partial question to you, Christian, but to Andreas Sattler, I have the more general question. Basically, I thought your key sentence, if I may say so, and you emphasized it twice in your contribution, was the options to efficiently give and withdraw consent are crucial for the success of the DA. But you didn't say how. And I'm really interested how, basically. So really, how should this efficient management of giving and withdrawing, and that's more difficult about the withdrawing, given the limits of Article 7.4 for GDPR, so how should this efficient management of giving and withdrawing consent look like? Basically, that's my question. And as I said, Christian, if you want to answer the general question to Andreas Sattler too, I will be most happy.
Maybe Christian, you kick off, and then You start,
Thank you.
and then Andreas.
I probably refer to Andreas as the wider issue because Andreas is much more involved in the general interaction than I am. I think I look at it very much as a consumer lawyer. But the way one might conceive of trading in data in the UK was effectively an agreement to exercise the rights to give consent or the rights associated with in a certain way in return for payment. Now the question is to what extent a total, an absolute, non-renounceable granting of consent would first of all conflict with the GDPR, but more importantly, to what extent it would be in conflict with Part 2 of the Consumer Rights Act, in other words, the terms controls. And that might well require some testing. I can see arguments going in both directions. There's in principle at common law no objection to permanently limiting or surrendering or agreeing not to exercise a certain right. For example, for the entire lifetime of a contract. But there might also be cause from a public policy perspective to say, wait a minute, this is treated in a very different way under the GDPR, even under the UK's version of the GDPR, which is trying to make consent slightly less onerous, and therefore there might well be still some kind of limitation. So I can't give you a clear answer on this one, Dirk, but I can see both possibilities. There's not an either or the way the law looks at the moment.
Yeah, thank you for the difficult question. But of course, saying that I said it's, that's where it depends on. Now, I don't want to have a commercial for my habilitation project that I did, but I tried in that book actually to suggest at least what would be necessary to put in these PIMs in order to make them work in that sense. And I also provided something where you have, because it has to be informed as well, where you use like colors like we do for nutrition scores and anything like that to make it, more practical. Under the current law, as you said, I think it's quite difficult to say that you can actually in advance dispose of your right to withdraw, and it would have actually been my question to Christian Twigg-Flasner whether he sees something like that in the UK under contract autonomy, whether that would fit with the data protection in the UK to say, well, generally I have a right to withdraw, but I might in contract dispose of it, even for more money, or even for let's say 3 months, and afterwards someone has to come back and ask me again, do you still dispose of your right to withdraw, for example. That was what I would suggest, but under the GDPR, and I suggested it's now legal methodology, theological reduction of Article 7, Para 3, I think it is. But of course it would be the European Court of Justice that would say, well, the right to withdraw consent at any time without giving a cause is too broad when looking at what kind of cases fall under the GDPR. And I think it's quite clear, actually, if the data subject at the same time is a business person, it would nevertheless apply. I mean, it's not an artificial case, but it's a narrow case where you say there's a natural person, that is, we Germans would say Einzelkaufmann or whatever, so an enterprise as well, and he is not able to even dispose of his right to withdraw consent. I think that is in a B2B relationship that we have. The data subject is itself, or he himself, or her, or she is a business person. Then no one will ever get the idea that a business person in a contract with another business person cannot dispose of its right to withdraw consent. I think that's quite clear that wouldn't be possible, but under the GDPR, even such a person would be prohibited from disposing of its right to withdraw consent. That's why I think there is a clear case where the GDPR shouldn't apply, where we should have a theological reduction, as I said, in methodology, because its wording is far too broad when it comes to withdrawing consent, if that data subject is a business person. And I think there might be cases where that might even be valid for consumers. Of course, we were then going to discuss about, having an informed consumer who transparently knows that he's now disposing of his right to withdraw consent without reason for, let's say, 3 months, so that the other part of the contract has some stability and has some reliability to use that data for at least, say, 3 months. That's what I suggested. But I think you will have other requirements when that is valid, but under the GDPR, it's not possible under the wording unless you reduce the wording of Article 7, Para 3, theological, and say it's just too broad in some cases. And that is something the European Court of Justice would have to do. I know it's like a really tiny window that someone has to go through, or the European Court of Justice has to go through. Otherwise, it can only be possible probably when reforming the GDPR and then saying, in general, there's a right to withdraw, but under certain conditions, it can be disposed of for a certain period of time. Whether you put in a time or whether you say for a reasonable period of time or whatever is the other question then. Difficult. But as I said, there is a case where I think it's necessary. If the data subject is a business person, it is completely necessary. You cannot tell a business that you're not able to dispose of your right to withdraw consent. I mean, it sounds to me at least that shouldn't be possible. Freedom of contract should prevail in this case.
All right, then there was Martin first, and then...
Yeah, thank you for those both inspiring presentations. I have tons of questions, but I reduced them to some of them. First, to go shortly to Andreas Sattler, and again on consent. You had a short formula in your presentation that perhaps without a valid consent, if I understood you correctly, the contract could be void even, or at least an obligation under the contract could be void. I'm not sure, perhaps you could elaborate on that, but perhaps I was misleading. The second is, again on the withdrawal problem. In the Data Act, we have another sort of consent in Article 4, paragraphs 13 and 14, where 14 we do not really know whether it is a consent or not. Could that also be withdrawn? Is that of the same kind and category in your view? And Christian, you mentioned here sui generis contract type. Any forecasts on what details could be in, and where for such a contract perhaps there should be a deviation from general common law rules? And to both of you, as Andreas Sattler's emphasized so much the need of consent and data management systems in IoT devices it was referring to, the lacking of an effective system of such kind, is it also kind of defect of such a system, of the IoT item, so under sales law or under the Consumer Rights Act?
Andreas, you go first, and then Christian.
Yeah, sorry, I wasn't too sure about your first question. Maybe we can come back later on, because I don't remember that I said. Yeah, I guess we can discuss that later on. Second question: the consent under the DA. I mean, as far as I see it, the DA doesn't mention a consent in the sense that it's a different content from the GDPR as far as personal data is concerned. So, and as Article 1, Paragraph 5 says, whenever there's a case of conflict, please go to the GDPR. So I doubt that we could say that under the Data Act there's a form of consent mentioned that even doesn't, when it's about personal data, that would give us some valid basis where we could exclude the right to withdraw consent. I would always say then Article 1.5 applies. It's a case of a conflict because personal data is concerned, so please go to Article 7 GDPR. So I don't think the Data Act changes or reforms consent as defined by the GDPR. It might be different when consent is considered to non-personal data, or whether it's just a general term for, let's say, contract in that context, and you say, well, you allow access to general data that is generated, which is not personal data, and then it's a different story. Then the second question, can you repeat? Yeah, I think it's difficult because I mean, I wouldn't say it's an objective expectation that you have a PIMS or a management system on it that tells you how consent, or that allows you to, take serious your right to withdraw consent and to give your consent to specific purposes once a year, once a month, or once a week, or something like that. And especially, I would have some doubts because it was not until last year when the Grand Chamber actually told us, which bases can we use, which are the valid bases under the GDPR. So you could at least say, not until July last year we did actually know what would be required when such a device was given to you. So I think that's a bit intransparent if the current case law on Facebook then decides what an IoT device could be expected of, I think. That's why it's probably more to the data protection authorities to implement that such PIMs might be contained in IoT devices at the moment. That would be my... I mean, of course, if you agree on it, then it's different story. Subjectively, you can, of course, agree. But as an objective requirement, I think it would be to go too far.
Christian?
Thank you. Yeah, on the question of what such a sui generis contract might look like, of course we don't know because they will be developed at common law. That requires cases to actually reach the courts and, particularly in consumer cases, but also data cases generally, we don't have that case law. In fact, when I looked at the index to the latest edition of Chitty, which Yubil kindly plonked on my desk a couple of weeks ago, even in the 2 volumes that run to multiple thousands of pages, there's no mention of the word data at all. So I think it's not quite hit the agenda of the courts just yet, apart from, of course, in specialized data protection cases, but there seems to have been no impact on contract law so far. Just on the side of the consent point, I mentioned earlier, when these wonderful data regulations will eventually be adopted under the new act that's coming through, yes, the intention is to not violate the consent rights and other rights under data protection legislation. But again, if you look at the clause as currently drafted very carefully, it does seem to open up the possibility of some derogations. And one of the strange peculiarities of secondary legislation in English law and UK law is that such legislation can occasionally amend or qualify or restrict the application of primary legislation. And to all intents and purposes, the UK GDPR is classed as primary legislation, and there's nothing to stop those new data regulations from somehow modifying the extent of consent obligations and indeed modifying the extent to which consent may or may not be withdrawn. So there's going to be, I think, there are some answers to these questions forthcoming, but we won't have those answers until the government, this or the next, have actually drafted the regulations that will have legal force and will apply to this idea of data sharing once the Act itself has been adopted. So some interesting questions yet to be answered.
Thank you very much. Then there was a question here.
Wolfgang Kalber. Many thanks, Andreas and Christian. One small remark, is withdrawal with consumer data really an empirical problem? Can you imagine that there are many consumers who withdraw data? I only want to say from an economic perspective, this is very tiny and does not play any role for the data they're getting at the end. This might be a legal problem, I understand. But my main point is a question to Christian. At the end of your great presentation, you sketched somehow the basic ideas of a UK Data Act and regarding also of IoT devices. Now it's great that UK Data Act takes some time because then you can learn from the mistakes of the current European version of the Data Act. And therefore you certainly have looked, when you looked at what you have done, can you already see some, that they might avoid certain kind of mistakes that the EU Data Act has done, especially in the relation between data holders and the users, the consumers as users, because this is most interesting for us in this conference.
Maybe Christian?
Yeah, at the moment that whole situation is unclear. I think there are similarities in the way data holders and users are dealt with in the enabling provisions of the Data Protection and Digital Information Bill. And I think the real meat will be in whatever regulations ultimately emerge. Unfortunately, there have as yet been no consultations on such regulations. This particular bill itself has had a difficult journey through Parliament. In fact, this is the second time the bill has been introduced into the current Parliament because there were all sorts of objections and there was quite a bit of resistance. This looks like it's going to go through. We are now in the final report stage in the second chamber, so hopefully this will go through, but then it depends an awful lot on further consultations, detailed implementations, and at that point the question will be, of course, also to what extent whichever government is in charge and whichever government department is dealing with it, to what extent there will be a greater willingness to take due note of EU developments and to learn from the EU experience. At the moment, there seems to be an attitude of just not doing it in the same way as the EU, at least not calling it that. But that's a political position, and that political position can change as the government changes or somebody else takes charge. And that will have a big, big influence on how the EU-UK kind of comparison will ultimately work or not work.
Thanks a lot. Please, Andreas.
Yeah, I might come back to your point as well. I completely agree that one could ask whether this right to withdraw will ever be used by data subject or whether that has any benefit. I think one explanation would be if we are talking about the share of consumers in their personal data as well, evaluating and then letting them share, then withdrawal might be important because it might be one of the decisive factors of which consumer gets what, so to speak. I mean, depending on how many purposes you might have given consent to, might be one of the reasons how much money you will get as a share as a consumer when we talk about consumer data. At the same time, if you withdraw your consent earlier, you might get less remuneration, however that is going to happen and work. That's the one point. The other point is, I mean, as long as you can always withdraw your consent as a data subject who's consumer, means that at least some business models works. I mean, we had this conference in Bayreuth, and one of the main applications was the telematic tariff, so insurance for cars, and you pay and you get a repayment after the insurance period. Let's say I'm 18 years old, dangerous driver, and I pay and I would have to pay €1,000 a year for my insurance, car insurance. Unless I'm prepared to have a telematic, so have a corresponder that generates the data and tells the insurance company that I'm 18, I might be dangerous, but I'm a really conservative driver. I don't run on the motorway, not even in Germany, and therefore I only have to pay 800 and I get €200 back after the year because they were generating data about my behavior on the streets. So that's the only way you could solve these contracts if you say, well, if you have a right to withdrawal, because then they say you will only get a certain amount back if you haven't withdrawn your consent within the period you had this insurance. So that means you pay upfront 1,000 and only after not withdrawing your consent within 1 year, you get €200 back at the end of the year. Also because you behaved well. But it's also because that's the only point in time when the insurance company actually can be sure that you didn't withdraw your consent during the period of the insurance, the 1 year. Just as an example. You could say they can work with it, why can't others work the same way? But then I pass it on to Dirk Staudmeier because he posed me the question as well. And he seems to believe to some degree that it might be important to dispose of.
Thank you. Just about that last model which you mentioned about the insurance company saying you get the 200 over after a certain amount where you have not withdrawn the consent. How will that work with 7.4? Where it says consent is not free if it is linked with something of a detriment, basically.
Yeah, because they say it's only a condition. So there's only the condition in the contract that you don't withdraw within that period of time. You're still free to withdraw, but that would mean that you cannot get as much back from your premium as you decided to pay. And they put it in a different document, actually. It's not in the same insurance contract, so they want to split it, but they're nevertheless, I mean, it wasn't before a German court yet, but they are convinced that because it's only a condition and not seen as consideration in general, that it's possible to, because you're still free to withdraw, all it means is that you won't get a repayment. It doesn't change anything about your rate, so to speak, because you pay upfront 1,000, that was the rate it was agreed on, and only a year later on you get afterwards, ex post, you get a reduction. And it's of course also based on how you drive. So that's why it's difficult to say, you know, how much has it to do with withdrawing consent? What's the value of that? And how much is it you as a young driver or whatever age were a responsible driver and therefore you get the reduction? That is not completely transparent probably as well.
But isn't that cosmetics? Isn't it the same to say basically it's not a penalty, you don't get a benefit? Isn't that the same economically speaking? Because the thing, for instance, what one thinks about share of consumer data, I think there was a case in France where the French, the metro in Paris said, you have two abonnements for driving on the metro in Paris. One is we get your data, and one is we don't. And there was a price difference. Yeah? And basically the French data protection authorities didn't allow that, with the argument saying, well, actually, this is all bonus because it is not the people who are paying with data getting a better deal, it is the people who are not paying with data get a worse deal. So you can always disguise this differently, but the effect, if I have understood this model correctly, I'm not sure I have understood it correctly.
Economically, it is the same. I mean, if you just look at the value, then you could easily say, you know, once you have decided for the value, it's no longer a free choice whether you withdraw your consent. The other question is, I'm not sure whether it was in the French case, whether you could say, well, you have those two models and you really, you know, present them both. And you even have a third option where you say, once you withdraw your consent, during running of this contract, you will have to pay amount X. And then it's completely transparent that you are free to withdraw, and that would mean that you have to pay, let's say, €5 more for the next month during the contract, which runs for 12 months. So you have three options even, because you already agree now on what you will pay once you withdraw the consent in the future. Not sure whether, you know, I mean, data protection authorities, I'm convinced, will say it's void and it's not possible and it's not, you know, freely withdrawing consent. But I mean, if it's really transparent as well, I mean, of course we can always come over the angle whether that's really transparent and so on still. But if it's transparent, I think, you know, this should be valid, it should be possible.
As time is running out, so if you have further questions, please ask them during the break, and Rainer Schulze would have like to have some final remarks.
Just in the same line, unfortunately time is running out. I got the impression that we had a very intense and high-level discussion, a discussion with the participation of the speakers of this afternoon and of tomorrow, without participation of other persons in the room, without participation of younger researchers. And I want to encourage all of you to ask questions, and even to ask questions with regard to understanding or for more explanation, in case that you do not that you are not able to formulate your question now. Don't hesitate to note something and to come back to this by an email to the speakers, and that's a word to the speakers. We will have time until mid of July to write the articles, the written version of the papers we heard. So if you have questions, write it, you will get the answer directly or in the written version. And I encourage the speakers to include all these questions, and I encourage the speakers not to forget that at the mid of July we will terminate the written version of the papers, just to give all the results of our Congress to everyone within this year.
That's right. And now we're having coffee, so there will be room for questions. And one professor I know very well, he thought great academic careers are made by coffee. So please drink coffee and discuss. Thank you very much. Vielen Dank, Christian. Schön, dass du da warst. Schön, dich zu sehen. Bis bald.
Thank you.
Okay, welcome back to our next session. It's a great pleasure to actually have a panel with one of the three of the leading figures in the European legal debate. Let's just get started with Hans' presentation about price control. So Hans Schulte-Nörke currently has the chair of European Private and Commercial Law, Comparative Law and Legal History at the University of Osnabrück, and you're also the director of the European Legal Studies Institute there. I think we all know you, and we're very happy. And I'm really curious about what you can tell us about price control in the multi-level setting, so to speak. Hans, please.
Okay, thank you very much for the invitation and the warm welcome. I must admit I slightly changed my topic. I planned to speak mainly about general terms and conditions, but seeing I announced my topic rather early. Seeing the other topics, I thought I should better broaden a little bit to speak on prices in court, in particular in contract law disputes, and I brought you very few highlights from a very long story, beginning with some general remarks going back to antique times, 18th, 19th, 20th, and then finally 21st century on prices in court, in particular contractual prices. In general, this is such a tricky issue that it would take hours to explain why prices in court, monitoring, reviewing and controlling prices by courts is a big issue. You all know that the two basic approaches of states is ex ante, usually regulatory price control, or ex post judicial intervention into contracts, and this is complex because it's between freedom and intervention. One, let's say, point of this test is transparency issues. Sometimes you can try to cure problems by making contracts more transparent. Then, of course, you can start as a judge by assessing the market efficiency, and if there's a problem with the market, correct prices, but you can also start with the price-value ratio and conclude from that that there might be a problem in the market. And, of course, you can start from the position, the bargaining position, weaker, stronger, whether a consumer or not, whether there's need of protection. And having then found that judicial intervention may be necessary, you have to decide what kind of intervention should happen. And from a more, let's say, a bird's eye perspective, any price control need effective ways of enforcement, because usually the transaction values are so low that individual consumers don't bother, and therefore there must be other things. Price control is by far not new. If you like Latin and Roman law, you will of course know this very famous rescript of Diocletian in the late 3rd century. If your Latin is on the level of mine, the English translation, at least I somehow meddled in this translation, improving it or making it, streamlining it for the purpose of this presentation. But in any case, this famous rescript was the basis of a famous doctrine, the doctrine of justum pretium, fair price, and from the other perspective, lesio enormis, in the case the price is not fair. This is basic of European legal history, and most of you will know at least the late medieval and early modern times formula of lesio enormis, which is the 50% formula, or the double value then price formula, which then allows termination or claiming back the money. I skip anything on general on the role of states, but I only want to give you one example. It's a recent example, but nevertheless, which shows that value of data was also a problem already before the Data Act and the GDPR. One somehow funny case from my country from 1996 was the time when there were still printed telephone directories, and an innovative enterprise marketed a CD which was produced by 532 Chinese data typists. They typed all the printed telephone directories and then put it on a CD. And it was very difficult for the legal system to handle this. It started from, which is really funny, copyright. Copyright in a telephone directory is a nice idea. It ended at that time with unfair marketing practices. It could also have ended with the then very brand new intellectual property right in databases. That would be now, of course, the solution. But this is a case not on copyright, it's a case on value of data. Therefore, nothing new under the sun. Well, back to our historical line. In 18th century, this idea of a general judicial price control of course, not only data, everything, in particular land and property, I'm not saying ended, but declined. And one famous quotation I brought you is the idea of natural prices of Adam Smith, which of course means that prices, if market is okay, are natural, and judges should not, even must not interfere, because this would simply disturb markets. And this introduced the fall of the lesio enormis. If you like to read French, and if you're good in math, you will find out that the French Code Civil had, at least for land, for property, a slightly different formula than 50%. The 7 parts from 12 formula, but still had a clear lesio enormis. The German law went a completely different road. Lesio enormis was with big pomp abolished, but soon later, very soon later, Wucher usury was introduced and is still one basis of price control. What's the difference? You probably know or see from these texts. Usury means not only disproportionate ratio between price and value, it also means that one party exploited whatever the inexperience of the other party, had a subjective element, not just an objective. Control is probably something very different. However, in German law, if you zoom closer, you find hidden traces of the old lesio enormis. I brought you Federal Supreme Court decision on interest, and you wonder, but you see that the German Supreme Court found that if the interest rate is more than twice as high as a standard market, then at least there is a presumption of unfairness and therefore judicial intervention. However, 20th century situation changed, which means after the decline of judicial price control in certain areas or for certain reasons. More and more elements were introduced. One very famous example is from, again, Germany, 1922, the invention of a change of circumstances. And if you then again zoom closer, you see that courts had to assess the value ratio between performance and counter-performance also in these cases which were brought in these inflation times to courts. I skip other examples for this so-called materialization of private law. You have it in tenancy law and, of course, in labor law. We have since then and now more and more market sectors with regulated prices, usually through legislation, partially also indirectly through courts. I skipped that too. All of you will know that, of course, in modern antitrust law, national, European, you have a price assessment element. In particular, unfair selling prices may constitute an abuse of or by an undertaking of a dominant position. Again, courts have to assess prices and to compare them with value. And rather recent, but also practically very important example which brings us closer to data is intellectual property law, in particular standard essential patents. All of you will know that for example, in telecommunication, practically everyone who offers services needs these standard essential patents, and the solution for that is a license under FRAND terms, FRAND meaning fair, reasonable, and non-discriminatory. And what is meant by fair is, among others, the royalty rate for the license then obtainable for such patents. Now I come to one element of judicial price control, which was, at least when I planned this paper, my starting point. You probably all know, Rainer mentioned in his introduction, that there's an interesting element in the policing of standard terms. This is, it stems perhaps even from German law, jumped on the European level, and then was more or less distributed in all European countries, except a few, because it's a minimum harmonization, as you certainly know. The basic idea is that in standard terms, core terms of the contract, which includes, among others, the adequacy of the price, are not subject to judicial policing. They are excluded from the scope of the test. However, there's a broad and highly problematic exception. If this exception, this carve-out, is only applicable if such terms, core terms, including terms on price, are in plain, intelligible language, which means, of course, vice versa. If they are not in plain and intelligible language, courts may and must control terms on prices. I could now give a different paper on the about 60, I counted yesterday, cases at the European Court of Justice on how to close gaps in contracts where in particular the core terms have been kicked out because they are usually, first of all, double tests. If it's core text, you must first of all find out that they are not transparent, because this makes them subject to control, and then you must also find out as a court that they are somehow unfair, and then they have more or less they must not be the gaps must not be filled according to this case law of the ECJ, and therefore there is a nearly unsolvable problem, practical problem. I skip this problem for the moment because it's perhaps, to be honest, a mistake in this case law of the ECJ. But in any case, the interesting point for our purposes here is the underlying idea. The underlying idea is that, at least for standard terms, courts should not be entitled nor obliged to control prices expressed in standard terms as long as they are clear, because that is considered as the responsibility of the consumer, because as long as they are clear, the consumer can easily find out what the price is, and therefore it's his or her responsibility whether the price is adequate or not. That's a very important idea of consumer law, and the question is whether this underlying rationale is also applicable for data, which brings me to our topic. First of all, we have to distinguish, and we saw this already from the earlier presentations, between personal data and non-personal data. And you can often read that the consumer pays with data for whatever his GPS application on his mobile phone, but that's perhaps not entirely true in legal terms. The other way round, it makes a little bit more sense. The business pays in remedies, consumer remedies, for making use of data. That's, we already saw it. I think it was in Andreas Sattler's presentation, and I have it here again. In Article 3, Para 1, second sentence of the Digital Content and Services Directive, we have this famous celebrated sentence that the directive also applies when the consumer does not pay money but provides or undertakes to provide. Whether it's possible to undertake is a different question, but at least whether, when the consumer provides data, I cut it short, non-necessary data, in the sense that these data are not needed for performance of the contract. And therefore, the other way around is perhaps more correct. Than it's not the consumer who pays with data in a legal sense. It's more the business that pays for data, pays in kind and in consumer rights. That consumers have more rights than they would have without the provision of data. Let's have a look into the Data Act. The Data Act has at least one element, because there are so many relations we already saw in Andreas, there's the user, the data holder, the data recipient, perhaps a third party. We don't know precisely whether it's a difference than the data, but that's complex. In any case, in one relation, in the relation between the data holder and the data recipient, there's a very clear idea that there should be a payment for data, and somehow, surprise, friend reappears now for determining the compensation for non-personal data under the Data Act. I think you are familiar enough. The data under the Data Act is, of course, not all data. It's, I cut it short, it's mainly product-generated data. There's usually a product, a connected project, there's a user, which is often the owner, and there's a data holder, which is often the producer, and then there is this data recipient, that's another person, of course, and if the data recipient receives, which his name already says, data from the holder, open bracket, with somehow consent by the user, then in this relation between data holder and data recipient, there should be a payment. And this payment may even include a margin, not just costs, compensation for costs, also profit. That's an interesting, completely new idea, which makes very clear that data has a value, and there is quite a lot of ink invested in this Data Act, how to determine what friend terms are and what the royalties may be. I skip that too. And I dare some very careful tentative conclusions whether there is a lesson to be learned from this story or history for our topic. Of course, the easiest, most obvious lesson is that courts and, of course, other dispute settlement institutions have to deal with price-value ratio of assets since centuries, and this includes now data. That was perhaps not a deep insight, but at least I'm not saying there's nothing new under the sun, but it's not really new that courts have to deal with the value of assets, and this can include data, including perhaps consumer data. Then the second revolutionary conclusion is the law now recognizes that data has a value. This perhaps needed to be said. The third point is there is clearly no IP right in data, and therefore probably also no license in data. I admit to Andreas, it's pretty close. These contracts on data they look a little bit like license contracts, but nevertheless we may discuss whether it's the same or not. And then, if you look a little bit closer, non-personal data under the Data Act, which are usually not, but may also be consumer data. Well, first of all, they are governed by classical remedies we are familiar with in intellectual property law, but also, and that's new or stems from antitrust law, there is a friend requirement, but only in this relation between data holder and data recipient. Therefore, the question, what about the user? If the user is the central person in the whole system, the user at least directly gets nothing. I'm not sure whether this is really correct, because we have seen that a contract between user and data holder is necessary in order to entitle the data holder to give access to the data to any others, and there may be, of course, some consideration in that contract, but that's perhaps an indirect effect of a value of data. That's easy. Personal data, which is often consumer data, it's slightly more tricky. I already explained, well, a consumer gets for providing personal data some remedies. Most prominent example, a right to terminate. A right to terminate usually leads to a regime for the unraveling of a contract, which means usually returning what has been received. However, what about the data? There is no clear rule in the Digital Content and Services Directive that the business has to return the data. Would be also a strange rule, but however, if data have a value, general rules on regimes for unraveling of contracts would say that at least the value of something which cannot be returned in kind should be compensated. And if you read and read and read again, you find all sums paid by the consumer. Say better no than yes, I would say. Which means, obviously, this idea is not yet there, but at least would be in the logic of this element. I'm not so sure whether this data for my fitness tracker are very valuable, but even if it's a few cents, if you imagine the overall volume of such markets, also I think it was Rainer who had collected some figures, this might be worth thinking about. Same, by the way, more footnote than final remark is, of course, under the GDPR. You get a claim for damages, which needs in classical doctrine of private law, you need a damage, material or immaterial damage, which is the opposite. Something completely different from compensation for value. Compensation for value would be for doctrine lovers unjustified enrichment or something like that, and there is no claim for that. And therefore, I'm not so sure whether data has really a value, de lege lata, and I'm also not very sure whether I should really make a proposal to the legislator to introduce these tiny elements for these micro sums, amounts, data. The value of data would be in individual transactions. Therefore, as I said, I think it was to Herbert at the very beginning, problem description is pretty easy. I think I got pretty far insofar. Problem solving, I'm very much looking and hoping for my fellow panelists. Thank you very much.
Thank you very much. Yes, and I shall try. We have a joint discussion afterwards, but now we turn to contracts. And this one, huh? Yes. Okay. And I'm happy to announce our next speaker, Teresa Rodriguez de las Heras Vallel. Is that more or less correct? Yeah. Professor of commercial law at the University in Madrid. And also currently also visitor at Cambridge University?
Yes, already finished.
Excellent. Okay. Teresa, please.
Okay, thank you. Buonasera, grazie Alberto per l'invito. Thank you very much for the invitation, Rainer, Dirk, and Alberto. I'm delighted to be part of this panel and to talk about from what I have decided is a purely contractual law perspective through the lens of the policy strategy that, in my opinion, is vertebrating the Data Act. That is the reason why I have decided to propose this title for my presentation. Contract, because I would like to analyze and discover in the Data Act what is about contract beyond all the fabulous discussion that we have had today on the legal basis that is essentially consent when we are talking about personal data. But beyond that, indeed, the Data Act is about contract for accessing, using, sharing, transferring consumer data. This is indeed the scope we are discussing today. And one of the points that I'm going to defend and advocate for is that even if I can understand, and Andreas was very clear in this regard, that consumer data in the major part of the situation are going to be personal data, for me, Data Act is essentially about non-personal data. I'm not talking about the fact that it's not clearly in combination with the GDPR. It's definitely within the scope, personal, non-personal. But for me, the added value of the Data Act is how the Data Act identify that personal data, but most non-personal data, has a real value. And this value is locked and has to be unlocked, exploited, and transferred in the market. And the most clear and effective vehicle for that unlocking value, creating value, and transferring value is indeed contract. And that is exactly what I would like to do in the next minute that I have, trying to identify in the Data Act from the perspective of the consumer data, which are the elements that are essentially inspired by the traditional contract law. Therefore, what I'm going to do is to focus on one of the components of this universe, of this constellation that Alberto was referring before in his introduction, this constellation of different instruments that we have at the moment in the European Union regulation on digital law, that is the Data Act. So in the Data Act, we have essentially, in my opinion, two main policy objectives that are or could be encapsulated in these two terms: mobilizing the data value in the market and monetizing data. And when we talk about monetizing, I'm not talking simply about the possibility, that is definitely important, of using data as a counter-performance. That is the most evident way to use the commercial value of data. I'm talking about how data, and therefore the transfer of data, could, for example, enhance the additional or ancillary services that third party provide to the consumer, how we can indeed personalize the services, or how can you even increase the competition in the market, given the opportunity to other companies to provide, for instance, services around the main product that we are talking about. So that is, for me, monetizing. And in order to monetize, we need personal data, but essentially, we're going to need non-personal data. The vehicle that the Data Act uses is essentially contract, but it's very wisely combined with two other elements. One that we can discuss later, to which extent is contractual or is something completely different, regulatory maybe, are the design requirement. So there are many provisions related to design requirements. What are design requirements? How can we use that for the purpose of a private law analysis? What means the infringement of the design requirement, for example, apart from naturally infringing the regulation? But what is going to be, for example, the implication in terms of liability? We could use the logic of the rebuttable presumption that we have in the proposal for the Artificial Intelligence Liability Directive, no? This idea that if you are not complying with this certain requirement, maybe there is a presumption that a certain element for civil liability have taken place. So maybe we can find a way, but we have the design requirement together with the contract. In combination with a third element that is probably not explicit in the Data Act, but in my opinion is very interesting: practice. Sharing practice, data sharing practice. And that also opened the door to connecting naturally to unfair commercial practice when we talk about of consumer. So with this idea in mind, we are going to talk about consumer data, and in particular consumer data contract. We need to solve first the discussion, the fantastic discussion that we had before about the fact that to which extent data are asset, and therefore to which extent we can have contracts whose object to be delivered is or are data. And that is very important because we are clearly discussing what kind and types of contract we can conclude when we're talking about data. I have been discussing before about this idea, and we are talking about modalities. So what are going to be the modalities for accessing and using and transferring data? But if we talk about modalities that have a technical and organizational aspect, we're talking about as well type of contract. If we say that the modality is, I transfer to you a copy of the data for your exclusive use, and you can use it for any purpose, that is very similar to a sale contract. If I am saying simply, I give you the data for a temporary period, and you can only use that for that particular purpose, maybe this is a license. So, talking about modalities is talking about typology of contract, whose objects are indeed data, either personal or non-personal. So we need to talk about data as asset. I'm not saying property, I'm simply saying that we have to identify these data that are going to be part of the obligation of the parties as per the contract. If we take a look of the Data Act in the recital, and Andreas explained that very, very well and in more detail, there is absolutely no reference to the fact that data is property, and there is absolutely no reference about data is an asset. However, we have two elements that, in my opinion, are very revealing. The first one is that the Data Act is clearly about who is going to use the data, and the which condition, and on what basis. So what is that? We're talking about data as the object of certain contractual obligations and rights. That is exactly what data says. In the last sentence that you can see on the slide, Data Act is also clarifying another point that Andreas has explained very well before, this idea that the regulation is not creating a new legal basis in favor of the data holder. Okay, so certainly we're talking about the fact that the consumer is entitled over the data that, according to the Data Act, personal or non-personal, are considered product data and related server data. Why? Why? Why the consumer is entitled? Has any kind of right or entitlement over those data? What is the legal basis? In the case that they are not personal data, of course. The other perspective, therefore, is the perspective of the LI principle on data economy, the American Law Institute and the European Law Institute. What is the approach? The approach of this principle is that in those kind of cases, the consumer using a product, the product is a smart connected product, is generating data. These data are related to the use of the product, they are related to the activity of and the performance of the consumer in relation to this product, etc., etc. In those cases, as you can see, we are in what this principle describes as a co-generation of data. And if we talk about a co-generation of data, the co-generated or co-generating parties involved have certain data rights. And one of these data rights is precisely economic share in profit derived from data. So as you can see, the other possible perspective is to consider that in those cases where the legal basis is not evident, is not clear, I know that probably you are thinking that in most of the cases, any data generated by the product is going to be a personal data unless it's anonymized. Of course, I can accept that, but I think that there are many, many, many cases where they are going to be non-personal data. And I would like to understand why suddenly the consumer has this data right over this data with an economic purpose. And that is another perspective, another explanation that I find particularly interesting. The second element that I would like to discuss with you is when we talk about consumer data, what that means. Consumer data. I'm not trying to be very provocative, but I would like to discuss and challenge this question. Why is that? Because when we say consumer data, in the context of a consumer contract, all the data related with that particular relationship, we could consider they are consumer data. But in this case, what we really have here is a bundle of different contracts. Some of them are clearly consumer transaction, but other are not, or more important than that, and I will explain that in a minute, more important than that, the data sharing contract we are talking about is not included in this contract. It's a contract that is certainly related, but is stacking on the three contracts that you can see over there. These contracts on the left side, I will explain that are consumer contract, they are B2C contract, but the other one, why we cannot question it? Let me explain. We have a consumer using a product that has acquired from a vendor. So we have clearly a consumer transaction. Then we have a relationship between the manufacturer, that is going to be in this case for simplicity the data holder, and in relation to the product and the consumer. And this is also a consumer transaction. And then we have another transaction that is between the provider of the related service and the consumer. And this is also a consumer transaction. But none of these transactions are covering the data sharing contract we are talking about today. The Data Act is precisely the legal basis for including that particular data sharing contract by way of request or a contract according to which the consumer take control over the data and decide to transfer or make available to the third party. So even for me, I don't want to be too critical on this idea, but even for me, the idea of consumer data has to be nuanced and has to be refined carefully, because the consumer is indeed in the weaker position as a consumer in relation to the transaction, but not necessarily in relation to the data sharing contract. And why I say that? Because when I will continue a few slides ahead, I would like even to raise the following, I know that controversial statement, but if we have a consumer who requests data and decide to share the data with a third party, do we still are in an asymmetric relationship? Is indeed the consumer in control of the data in an unfavorable and weak position, or is exactly the opposite? Because has the control of the data and decide what to do with the data. Are we going to apply to that contract, the one between the consumer and the third party, are we going to apply unfair terms as well? Or we are going to apply the model contractual terms that we are elaborating in the expert group that I am member of, even if it's not business to business, but consumer to business. So I'm just trying to raise point that I wouldn't like to take for granted, because I think that if we do that, we are not making a proper distinction between all the different contracts that are involved here. For example, if we have a situation where the consumer has not acquired the product, the smart product, but has a lease agreement, that is going to impact on the data sharing contract as well. So depending on the contract in relation to the product, the data sharing contract are going to be different, for instance? Or we are going to have a standard data sharing contract completely independently of the kind of contract that are underlying this relationship, for instance? For example, all the elements that we have in the Data Act related to design requirement, as I mentioned before, are indeed part of the contract, the data sharing contract, or the contract between the manufacturer and the consumer. And that is going to be important because in case of infringement of this design requirement, I would like to know as a consumer what is indeed the contractual relationship that is going to give me the action or the remedy in case of violation of that particular design requirement. So I think that is a little bit more complex than simply saying we're talking about consumer, therefore consumer data, and we apply consumer protection law to exactly which transaction and in relation to which kind of party or counterparty. If we go to the other side of the picture, where we have a consumer who can request the transfer to the third party or could request the data for the purpose of transferring to the third party under a variety of modalities, could be transferred, could be providing access, could be temporary access of the data, could be, we don't know, there's significant modalities. So my question is going to be the consumer involved in deciding these modalities of data sharing in both cases? So when I ask as a consumer to the data holder, make this data available to a third party, can I decide in which conditions? Can I decide in which modality? Can I set a specific condition with certain limits? I'm talking about parties' autonomy to the maximum extent possible, or there are something in the peculiarities of these kind of transactions that we have to take into account. What is going to be the liability of the data holder? For example, I can imagine several cases. The first one is what happens if the data, when provided to the third party, they are insufficient or inaccurate? To which extent that generate liability on the data holder? In which terms? Arising from which type of contractual relationship? If we consider that the request, the simple request, is a relationship, it's an offer, is a proposal for the conclusion of a contract by the data holder, we need to take into account, therefore, that this liability is going to be probably a contractual liability. If we assume that the request is a kind of set of instructions that I give to the data holder for the purpose of complying with my wills, my expectation, how my contract, how my data are going to be shared with the third party. So do I have as a consumer certain expectations? because that is going to be important for me. If I want that my data are shared with the repairer or the maintenance service provider, is because I want, first, general expectation, that the market is more competitive. Second, that there are services more, let's say, adapted to the particularities of the product. Maybe that the prices are more competitive. So there are certain expectations why I want that my data are going to be shared. How do we incorporate this expectation in the logic of a contract that has been required, triggered by the request of the consumer, but is going to be concluded by the data holder with the data recipient with, and this is my question, which level of involvement and determination of the consumer in that regard? The work that we are doing in the expert group on model contractual terms is precisely related to the unfairness that could undermine the relationship between the data holder and the data recipient. And therefore, the model contractual terms try to equilibrate, to rebalance a situation of asymmetry that could be related to the fact that some data holder could be monopolistic or oligopolistic or could have certain stronger bargaining power in the market. But this is not related to the consumer possession in this regard. So I would like very much to combine this effort that we are doing for the purpose of ensuring the fairness in this second level of the market with the expectation of the consumer that is indeed the one who trigger the entry into of that contract by the other party, data holder and data recipient. Let me just go to the two main points that I would like to discuss with you. So first, we use the lens of the contract and we try to understand Data Act from the contract law lens. Then we question this idea of consumer data. What means consumer data? If we have consumer contract, but then we have another layer that we have to discuss to which extent is indeed or not a business-to-consumer relationship, just again being provocative and in order to raise certain discussion. The third point is the Data Act providing a specific consumer protection solutions? So are there in the Data Act consumer protection rules, consumer protection mechanism, as we are habituated to? Indeed. If you take a look of the provision related to the design requirement, if you see the provision where the manufacturer is obliged to provide detailed information and the related service provided as well, what are going to be the data to be collected, this is the very, very typical measure of information and transparency. So we have indeed certain elements that are very much consumer protection measures. And definitely, even the idea of the possibility of exercise the request, in a way, is empowering the possession of the consumer. So the consumer can exercise this request, and therefore you are in control of how your data are used. In particular, I find two provisions that I would like to contrast with the general rules on unfair terms and unfair commercial practices. So it's clear in one of the recital that when we have a consumer, we apply the consumer protection legislation, in particular unfair terms and unfair commercial practices. But there are two elements related to both. And in my opinion, because it's lex specialis, probably complement or add the existing protection of these two directives. The first point is the provision that provide for the following. Users and data holders may contractually restrict or prohibit the access, the use of the further sharing of data, if such processing could undermine security requirements. The Data Act used the term user for combine, as you know very well, comprise consumer and so natural and legal person. There is, unless I is my mistake, there is no specific restriction to that particular provision when we have a consumer. So my question is, either we interpret that consumer can negotiate with the data holder this kind of restrictions, and this is over and prevail over unfair terms and other consumer protection, or that has to be properly aligned with the consumer protection in general, and therefore, in this negotiation, we will apply the filter of unfair terms. That probably is the most convincing analysis. Unfair commercial practices. This last provision that you can see on the right side at the bottom is a provision that is clearly, in my opinion, talking about dark patterns. It's talking about how the design of the interface, how the design of the mechanism through which the consumer is going to exercise this freedom, and in particular the request, is done in a way that is misleading or is restrictive of the exercise of the freedom of the consumer to exercise this right. So this is very interesting because it seems to be a specific provision that complement unfair commercial practices. It's definitely, in my opinion, a dark patterns situation. So the last point that I would like to raise is what happens when is the consumer the one who wants to take control, gain control over the data, and therefore negotiate with third parties in order to make this data, consumer data, available to third parties. So there are many questions, but the first one is, as I mentioned before, if we are here in an asymmetric contract or not. So to which extent here is the consumer still a weak party? I know that I am probably challenging and questioning many fundamental elements of consumer law, but I think that it's important to understand the intricacies of this data economy when we have all these actors involved. So is really the consumer weak party here, or is on the contrary in control? Or maybe you are considering exactly the opposite stance. Maybe the consumer is more vulnerable than ever in this kind of situation because it's extremely dependent upon the possibility that has to negotiate with third parties. When we have elaborated, and we are in progress, in process of elaborating the model contractual terms, one of the most important elements why these model contractual terms try to mitigate the friction in the market is because negotiating these types of contract business to business is extremely costly. It's very complex. Therefore, there are a lot of transaction costs. Transaction costs in negotiating, transaction costs in drafting, in monitoring, in performing. What are the transaction costs of this kind of contract between the consumer and the third party who is a business? Higher transaction costs, less? Are we going to apply the model contractual terms as well in this consumer to business transaction? This is the kind of questions that I think we have to raise. Because in the context of our elaboration of the model contractual terms, we have realized that one of the most fascinating and disturbing element of data contract is precisely try to fit them into the traditional contract logic. So if we want to draft a contract on data, we immediately have to manage the difficulties, for example, of are we drafting a sale agreement? Are we drafting a non-typified agreement? Is a totally new agreement for the purpose of complying with the ultimate economic goal that is making the data available? Can we, for example, talk about conformity of the data? Is conformity of the data a concept that we can import from the CISG, for example, the Vienna Convention on Sale Agreement? Can we talk about the Article 35 threshold for the conformity of data? For example, if it's fit for purpose. On the contrary, we're talking about services. And therefore, all the logic of service provision agreement is the one that should vehicle the elaboration of this kind of contract. It's not easy because it's going to define absolutely many things to the extent that we need to understand what type of contract, and definitely, even if we have a quite standardized contract, we will always have to define what is going to be the applicable law in case of gap in the contract. So we need to discuss what is the legal nature of the contract in any event. Therefore, we need to understand what type of contract we are elaborating. And the last point is, all this kind of transaction understood as a bundle of long, complex, largely negotiated, discussed in depth, becomes extremely complex from the perspective of the consumer. And that is why the proposal of the Data Act to use smart contract as a mechanism to accelerate, streamline, and standardize this kind of data sharing seems very, very adequate, very advisable. And that is the reason why I would like to take this idea in order to conclude as follows. Are we really imagining a consumer negotiating in detail the specific condition of the contract? Or maybe we can imagine a similar scheme such as Creative Commons in the digital economy. So the idea of standardizing icon-based obligation, and therefore the consumer is going to define very quickly what are going to be the main obligation of the contract in a very easy way. One possibility. The other possibility, this idea of the smart contract are going to be applied to all the relationship as well, business to consumer and consumer to business as well. We're just talking about the business to business data sharing that in particular the Data Act is referring to. If we talk about smart contract, all the beautiful discussion that we have about algorithmic contract, what we are doing in the ELI, the European Law Institute on algorithmic contract, what we are discussing in the UNCITRAL, United Nations Commission on International Trade Law, Working Group 4, on the use of AI for the purpose of contracting, is going to be applicable here. If we have a smart contract, very simple, click, 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 and I have a data sharing, we could have malfunctioning. We could have divergences between what I intended and what was coded. We may have mistakes and errors and unexpected outcomes in case that we add certain learning capabilities with AI technique in the smart contract, and therefore we need to solve the liability in these cases. So, as you can see, first we have a very, very classical approach, contract law in its magnitude. Then we start considering what are going to be the implications if we have a consumer. Is simply adding the consumer law, that's enough? Or we need to adjust certain element. Third, this is probably too complicated, and smart contract, another standardization mechanism, such as the model contractual terms, could be indeed a solution. And I conclude with the last point. If the smart product is not working properly, we could apply as well the defective product liability as it has been revised, that apart from being revised for the purpose of incorporating a smart product, is incorporated in the damages to be compensated precisely the loss of data. So I hope that this kind of observation, discussion, insight are indeed triggering a future debate. Thank you very much.
Thank you very much. And that brings us to our last presentation. You already mentioned types of contract. Let's see whether we can move on here. So our next speaker is Martin Schmidt-Kessel. And sure, just a second. Yes. So you have the chair for German and European contract law, private law, and comparative law as well.
Consumer law.
Consumer law. Sorry. It's too late. So without further introduction, Martin, here you go. Sorry.
Thank you for the nice remarks, and grazie agli organizzatori, soprattutto a Alberto per avermi invitato qui a Ferrara, questa città meravigliosa. Okay, I will not address pricing. I will not address too much the core questions Teresa put on what kind of consumer protection we have, but rather look into the consequences of the rights to deal with the data as part of a contract, without the clauses. But I think because before we go to control the clauses, we should say what are the rules if there were no clauses, and that's exactly as far as I understood what you're doing there. We will do that in 3 steps. We will first start. I would like first to start with a clear line to be drawn between the GDPR and the contract law elements, because it is very important not to understand the GDPR as being part of contract law, but it is something on the objects on which the contract is. the second point is I would like to try to develop some ideas on what types of contracts dealing with the data we have, leaving aside, at least for the first part, sales law, because sales law only steps in through the back door, to my mind. And then I try to integrate that in larger contract structures. So first, separating the levels. As probably is not open to a general consensus, GDPR separates privacy from contract. And I think there's really, I am German, I know, so I'm biased, but I think there's really a kind of separation principle, keeping the spheres to some extent separate. And there are some good reasons for having that. The rules on contract enabling, for example, the necessity to separate the consent details from the details of the contract. There's an additional point that we are used to, when we have contracts for license contracts typically, but there we have that element in, but contracts for hire or lease, we are used to draw directly from a contract the right to use the object hired or let. And that's not present here in our cases. We need a separate issue. And I think that's another kind, from the GDPR perspective, to be emphasized here. On the other hand, younger EU legislation is confirming that principle from the other side to a certain extent. GDPR is mainly mentioned as an impediment to performance, but not as part of the contract in the Data Act. And also under the famous Digital Content, Digital Services Directive. I think it should be named otherwise. It's mainly a Digital Service Directive. It is widely irrelevant, in particular for the in part fictional payment with data, because it doesn't refer there to data protection law, to the GDPR. The directive applies completely independently of what data protection law says. I know it is difficult to interpret this famous Article 16 of the directive, para 2, what the consequences are. In my view, it's rather a clarification that, okay, we are not blocking GDPR to be applied here, and nothing more. If it would have been more something, for example, like a general regime for restitution or vindication, it should have been more elaborated here. So to put that part together, structural conflicts between GDPR and contract law are limited. One example we discussed with the presentation of Andreas Sattler, so waiving the right to object, waiving the right to withdraw, that is probably forbidden, but it's forbidden like a prohibition by public law rather than being part of contract law. Contract law rather aims to mirror constraints and rules to data processing from the GDPR when organizing contractual obligation, and that's what I would like to do in the next two main parts. And I'm not as sure how to interpret that general rule in Article 1, Para 5 on the conflicts between contract law and GDPR. Perhaps it applies to the DA, but we do not really have such a strict rule for all cases of European contract law, in particular in consumer law. It is not everywhere in, and therefore, no, we are on the same level. It's no longer comparing GDPR with national contract law, but we are on the same hierarchical level, and therefore we could also find other solutions. And integrating that multi-level system is, to my mind, a more general task for all of us. But I know I will restrict myself to the ideas of what is happening. And the first thing which is happening is what is the basic idea and picture of controlling data and data holding. And I think in both cases we are talking about kind of services. And that was also mentioned earlier. And I start with the controlling situation and the picture drawn by GDPR. And I start, perhaps surprisingly, with the responsibility of the controller for the data, which is, I think, a very important starting point. And we also have an obligation to provide the data subject with the data and to lead data after the end of the relationship. So if we put it in terms of contract law, it sounds completely differently from the structure of the GDPR, which has a different idea. But when looking from it, so what is the picture drawn from a contract law perspective? The system, to my mind, is a bit different one. We have a general accountability of the controller. He has to report. We are now discussing how far. So how far do we have to report, for example, on earnings made out of money, etc. But there is a general idea of accountability of the controller. We have the limitation of purpose determined by the data subject mainly, at least in all the autonomous cases of autonomous justification. So it's also a kind of service, obviously, in the interest of the data subject, and there's no free use for own purposes, as Teresa also has mentioned before. And I think it's a service in favor of and in the interest of and on behalf of the data subject. So it comes close to a mandate situation, rather. Doing the same now with the data holding rules, I think we have first to accept that we have not only articles 3 to 7 in the Data Act, but also 8 to 13, and 8 to 13 could also cover new national rules on access to personal data. So therefore, I think we have strong reasons to think over the general principles also for the personal data issues within. We have to solve the other topics as well, and I will come back. So what is the general picture drawn? And it's not too much to be found here. We have the front conditions Hans mentioned before towards third parties using the data. We have the fair pricing, the right to establish technical protection measures. We have also a purpose limitation here, which to my mind is a very important red line within all of the elements we are talking about. We are talking about purpose limitation, and the question obviously always is who is setting that purpose. But in many cases, it is the data subject or the user. We have limitations to dissemination, which obviously could also be interpreted as part of the purpose limitation point. So it's not really a clear picture of the nature of the relationship, but there are some elements which we could adapt to certain types of obligations and contracts. And if we go into the details of 3 to 7, so the IoT device data, we have no autonomous right to use. So the data holder remains rather an agent than a free participant in the market. We have no autonomous right to disseminate the data. We have obligations of the data holder to dispose of the data according to users' instructions. So there's even a right to instruct. So again, the typical mandate element. There's a picture of a kind of subsidiarity to the user of the IoT device. So, and that's, to my mind, the starting point before we are talking about rights to be conferred on third persons to use the data, but that's the starting point of that inner relationship between the two. And there's a picture that the data holder is acting in the interest of the user. Consequences. EU law is about to establish a kind of category of market participant in control of personal and non-personal data, and these rules are particularly established for situations where another person has a better right in those data. So it comes close to a kind of trustee or a bailee. That's more the common law institution of bailment, which I think we are rather close to here. General rules on data holders are at least open to support such situations. The general rules in Article 8 following are not as clear as to give such a direction. So we have a tendency to establish market participants in control of the data in acting in the interest and on behalf of the person in a better position. We have it with the controller, we have it with the data holder in the sense, obviously not the Data Governance Act, but the Data Act. What is happening, what are the pictures for situations of rights to use for an own interest? There are some indications in the GDPR. So the GDPR, on the first hand, does not provide for particular rules on contracts for right to use personal data. I avoid the term license, obviously, for a good reason, because to my mind it is too much connected to intellectual property. 6.1b does not accept the contract for use as a justification to the user, as opposed, as I said earlier, to the usual consequences of contract for lease and hire. 6.1f perhaps could justify processing as a contractual use to some extent, but probably could not lead to an exclusion or prevention from the user from objecting under Article 21 GDPR. I think that's part of public policy so far. Consent is therefore, and we agree completely there, the only relevant way to organize. The GDPR also, in this case, provides for several additional and ancillary rights and duties to the parties, which are basically no contractual rights, but which are there due to another kind of relationship. So no probably indications really on how to construe a contract for the use of the data. It's only the protective issues which are dealt with here and the justification. When we're looking into the Data Act, the Data Act provides for a framework of rules on contracts for use, mostly but not only for the IoT data. Here I put them together. First, there's again purpose limitation as a general rule, including an obligation to delete at the end of the contract period. So it really comes close to something like a hire here. There's a responsibility for integrity and security of security of data subjects as a general contractual duty of the user, including prohibition of profiling. And the IoT device, and also integrity and security of the IoT device and connected service. There is a prohibition of unconsented dissemination and a prohibition, and that's new, that's not within the classical frame of contracts for use, a prohibition of monopolization of consumer data, and that's obviously a consequence of the non-rival nature of the data. So there are detailed elements of a system for contracts of use of data. There are also some, but only limited, indications of the directive on digital services and digital content. As we all know, the directive applies where the consumer provides or undertakes to provide personal data to the trader, and that's obviously not done for fun, but for use. A consequence is seems to be a responsibility, the obvious consequence is the responsibility of the enterprise, of the trader, for the quality of the digital content or service to be supplied. What is remaining open is the rather enigmatic cross-reference. I mentioned it before. And there's a clear reference that there's something left over for the member states, that the directive should not regulate the consequences for contracts covered by this directive in the event that the consumer withdraws the consent for processing of the consumer's personal data. Such consequence should remain a matter of national law. And I think we could at least, it's always difficult to draw directly something from recitals, because they are not binding as such, but they need some legitimation to become binding, but the way to legitimate them here is interpretation of the rest of the directive. So what we at least have is existence of use of data on a contractual basis. So we are clear that in those contracts we have a use element. Yeah, even if it is a sale contract as to software, what probably is not possible, at least under German law, because we would not accept a sales contract without having as counter-performance a price for money. So that's a bit strange in Germany, but and perhaps in other countries it's different. But I think in most cases, and also in the directive, in the 771, it's only for a monetary compensation. Now, okay, consequences generally. Contracts for use of data do exist under EU law. And the GDPR does not structure this relationship, but co-regulates it only in terms of data protection, and they call that the custody element, which we are very familiar with in every situation of a contract for use, that we have a kind of custody of the user for the object to be used. The DA established first elements of the contract, for use of data. Okay, that's the story so far. So we have clear hints to kind of services in the interest and with a custody element, and we also have first elements of a European contract for use data. Only first elements, it's not more. Perhaps we could draw something more out of it, but that's, at the moment, it's only reporting what we have. One thing we should not forget with all of that is that we are mainly, when we are discussing here, we are mainly talking about data processing and data use being the main element of a contract. But that's not necessarily the picture we have in the Data Act, depending on which relationship we are talking, obviously. Just the practical relevance to large extent is dealing with the data as the service element or the use element is rather an ancillary issue for the contract parties. And that's exactly the case in Article 3, 4, and also 5, because the main element there is buying or hiring an IoT device. That's the core of the contract. And the same holds true also with the references in the Digital Services Directive, where we only have, for some ancillary questions, references to data. So what we have, at least to a large extent, and probably also in the relationship between the data holder and the third person to a large extent, depending on the purpose of the use, that it is only an ancillary element of the contract. And the European rules do not often fit with this ancillary or mixed situation and character. For example, the remedies in Article 11, para 2, sometimes are dealing with as if the use of the data should be or could be the whole story. So more or less ending the whole situation, that's the core of it. And obviously, where we have it only as an ancillary element, it's possible to end a whole contract for breach of the data obligations, but it's not necessarily the case. What we need here are rules and concepts on contracts with ancillary duties on the European level, and in an abstract way, because we have lots of them here within those, in our rules. What do the principles of efficiency, we should ask, and equivalence ask for there? So we have to develop that when interpreting. By the way, this ancillary point, to some extent, solves Hans' problem, because then we could control the rules on passing on the data, because they are not the core of the contract. And to some extent, it also answers your question on why should the consumer have that right, because he paid for it. If you look at the types of contract mentioned in Article 3 and 4, we are only talking about non-gratuitous situations. Sale, hire, and this enigma, you know, it's could be lease, it could be leasing. We do not really know what it means. But it's non-gratuitous, that's for sure. And the seller or the lessor, and that's the second part of the explanation, would be in breach of his own obligations toward the user, and that's the second part of the legitimation, why the obligation to serve the user also is on the data holder, I think. So, if it is not as ancillary, someone told me that Facebook is a model of exchanging gold with some pieces of glass. And if we would change that perspective in that direction, the main point is providing Meta with the data. So if we do not go so far, we at least have to talk on mixed situations. And I completely agree we need to find the types of the contract, and I also try to find sometimes and develop some rules for sometimes, but I think we are rather, these are not types of contracts, but types of obligations or of part of the contract, because mixed contracts there are, to my mind, the new normal. We do not really know what the preponderant part is, to take the criterion of the Vienna Convention. Mixed situations are, to my mind, the new standard, including data control and data use. And we should not ignore that EU law is also about to establish general rules for such mixed situations. I do not know whether all of you recognize where I got that formulation from. I will make it clear afterwards, but we could try to formulate as a general rule where a single contract between the same parties includes in a bundle elements falling under this legislative act and elements of provision of other services and or goods. This legislative act shall only apply to the elements of the contract falling under this legislative act. So probably you recognize it. It's from the Digital Services Directive, and I just changed the text to generalize it. But we have similar rules also impliedly in Article 3 and 4. Then, because it's quite clear that we're here defining elements of sales contracts to which Data Act is limited, apart from the question how far it is reaching in the other parts of the contract by way of efficiency and equivalence. But basically, there are some limits. The only question is where they are. So the basic structure of EU law tends to follow combination solutions. It does not absorb all the different elements to one type of contract, but combine several types of contracts and obligations. So just to shortly sum up, I hope I'm in the time frame. EU law organizes first a two-level system on data contracts. Second, EU law establishes a contract element for service and custody to process data in the interest and on behalf of persons in a better right, whatever that might be. EU law has started to develop a basic structure for contracts for use of data, which includes also an element of custody and service in the interest and on behalf of the person in the better right. And under EU law, such contracts to a large extent have to be focused on as elements of a larger contractual structure. And last point, mixed contracts are probably the new normal in EU law, and EU law tends to apply a kind of combination solution to them. Thank you for your attention.
Thank you very much. Thank you all, thanks to all the speakers for this series of presentations with some very interesting new perspectives I haven't thought about before. The floor is now open for questions or comments from the audience. So who would like to go first?
Then I try again. Thank you very much. I'll pick up on something what Hans said, but I'm happy if all the panelists react. So first of all, I found it was very illuminating that law has, let's say, struggled with letting courts deal with price regulation in contracts. So I found that very interesting and reminded me a lot of things. But that's not really what I wanted to talk about. My main is more a comment than a question, if I may, or two comments, not so much of a question. You said that de lege lata, personal data has no value. Yeah, I would contest that, because basically Article 9 includes also personal data. It's just in a B2B relationship. And if one says reasonable compensation, but it also includes reasonable compensation with the data. So basically, what I would certainly agree with is that the consequence of the Data Act is that the Data Act does not deal with what is one underlying question of this whole conference, whether how much the consumer gets out of it if a consumer grants access to data to the data holder. But I would definitely say this does not mean that the Data Act does not recognize that personal data has value. So that's my first comment. My second comment is you spoke about a few cents in individual transactions. Yeah, that's true if one takes one transaction. But a modern car transmits 5 gigabytes of data every day. And if you accumulate this over the lifetime of a car, yeah, that gets you to quite a lot of data, even for one driver. Obviously, the real interest is if all these data are aggregated. I totally agree with that too. But it's not a few cents. Even for one consumer, it's not a few cents in individual transactions. So basically, what I'm wondering about is you left the solution to the other panelists, and that's why I'm wondering to what all the panelists say. So basically the question is, do we need something here? Because the Data Act, I can tell you, we did not deal with this issue intentionally. And the reason was very simple. Basically, we did not want to overload the boat in order to make it sink. Yeah? And basically, we said, okay, let's see. and now we're seeing, because we're discussing this in this conference. Thank you very much.
Okay, you'd like to answer directly?
Well, first of all, if you look on an individual consumer transaction and wonder whether the consumer can monetize his or her data, I still have my doubts. At least until now I never managed to monetize my own data, and I'm afraid that this will continue. I do not want to repeat, I read it even on the plane, all these calculations, how much worth is our data. You can, of course, have these nice calculations that whatever takes the over annual turnover of Facebook and divide it through the Facebook users, and then you end up in €100 per year or so. But has anyone received €100 by Facebook, or at least I don't think that it works, and it will probably also not work with cars. But let me say something different. Article 9 of the Data Act, sorry, I wanted to look into it before it's wrong, deals with the relation between data holder and data recipients. I think we can agree easily on that. And of course, there is some money in. And but my simple thesis was the consumer does not get anything. That others make money with consumers' personal data, I've never doubted. That's precisely the basic idea of the business, and therefore I don't see this contradiction. Yeah, I stopped myself. I could continue, but I will leave the floor to many others.
Okay. maybe the consumer gets something by the recipient, but I don't know who wants to step in.
The first thing is the consumer gets something by the third person and the recipient. And there must be a contract, and that contract...
But no money. He gets a service, added value.
Something of value. Added value is a good word at that. And then a counter-example for the individual case. We have all these financial leases in cars. And that in the end, we have these amortization necessity. And we have the calculation there. And if there are data in a value of, let's say, about 2,000, 3,000, 4,000, depending on the car and the kind of data and the kind of use, euros at the end, then we have to redefine those processes at the ending of the lease, of the financial lease. And that's a bit more than some cents there. Yeah, and so I think we have, and the 200 euros in the, so we have those cases, and I'm very grateful for all of them, and I think that the financial lease in cars would be a good example for consumer organizations to attack the actual standard solution on that, exactly in that respect.
Okay, so Andreas, you go first.
So I've got a question for Teresa, because I think it's already really difficult to draw up standard contract terms in the B2B relation. But as you said, you have the whole of contract law to put it within there. Are you considering contracts to the detriment of the third party? Because if you're looking at the B2B relation, the user will probably, I mean, you would have to check all your standard terms and whether they are somehow to the detriment of the user, who is not included in that B2B contract, but nevertheless the Data Act takes a user-centric view, and we have the principle of having no contracts to the detriment of a third party. Is that considered within the working for standard contracts in the B2B relation?
Thank you, Andreas. It's a great point indeed, because one of the element that I was considering precisely when doing the intervention is to which extent the user is this third-party beneficiary of any kind of right, and to which extent that change, a triangular, or that depend of the legal system, what is going to be the consideration. Note, indeed, so far we have no provision that take into account with this idea of a third party that may be beneficiary or may have a right that we want to protect, or may have a benefit that could arise from the contract. There is no specific provision in this regard, and that is an excellent point, because model contractual terms so far has been devised taking into account this idea of two companies concluding a contract for the purpose of one company to deliver or make available the data to the other company. Why this company data holder is entitled to do that is completely outside of the picture in the drafting of the model contractor terms. So I think it's a very good point that certainly the working group should discuss, to which extent that is a relevant element to incorporate. Okay. Thank you, Andrea.
Thank you. I have basically two questions concerning your project. By the way, the explanation about the contractual relationships was really interesting. My first question is, given that, is it kind of suggested that smart contracts could facilitate the standardization of relationships? Is it also implied some sort of self-sovereign identity in the sense of enabling the users, basically forcing the user to have an electronic wallet, because otherwise there is no way the user can interact with a smart contract which runs on top of a blockchain. The only way to interact with a blockchain and smart contracts is an electronic wallet. So this is my first question. And I think, by the way, that it would be a good solution, because through a wallet that I myself as a user can manage, I have an interface, an online interface, through which I can pre-flag what I want, I'm willing to share and what not. And also I think that provides more transparency, because think of cookie banners, okay? Each time we go to a website, we see very different cookie banners, and even for me, that I'm a lawyer, each cookie banner feels like learning over and over again because each banner is designed in a different way. But if I have my own wallet, my own interface with which I'm familiar with, it's different. I know how to use it. I mean, I don't know it at the beginning, but over the time I will learn it, hopefully. So this is my first point. If some kind of wallet simplified is envisioned, self-sovereign identity, some people would call it. The other point is standardizing to smart contracts. If we want to make it really transparent, in my view, should be based on smart contracts whose code is public, like the standards of Ethereum, for instance. In that way, the code is disclosed. This is the advantage of open source software. Anyone having programming skills can go there, read the code, and be like, yeah, it means exactly what they claim. But if the smart contract is programmed by a company, let's say, and the code is not disclosed, how can I trust the smart contract? Only who developed the smart contract really knows how it works, unless we imply some form of audits, which in turn would increase the cost of technology adoption, in my view. So these are the 2 points that I'm basically raising.
Thank you very much. Very, very interesting point. I like very much how you interconnect all the different elements, because indeed in the Data Act, if you read the recital, the Data Act is not providing a private legal regime for a smart contract. Has a very much limited and narrow goal in this regard.
Yeah, it just says, if you want to use smart contracts for data sharing agreements, this is how.
This is indeed, even I would say, even less. There is a list of requirements that the vendor of smart contract, for the purpose of data sharing, need to comply with. That's why I make this reference to which extent not complying with that standards could have some private law consequences, such as this rebuttable presumption of civil liability. So this is very important, because that means that the Data Act has taken the opportunity to incorporate an anchor with smart contract without indeed going or diving into the private legal aspect of smart contract. That's why there is, just to give you an answer to the first question that you raised, there is nothing about e-wallet, identity, connection with other directives that are in a way completing the legal regime for smart contract. But definitely it's a great idea, in particular the point that you referred to about flagging. That would be my initial preferences for the purpose of negotiating or concluding data sharing in the future. Another point that you mentioned is you refer to smart contract naturally in the context of DLT, smart blockchain models. In the recital of the Data Act, there is a very particular nuanced statement saying smart contract here is used in a very general way, is not necessarily linked to DLT, distributed technology. So this is about your first question, that is excellent. About the second one, is indeed very important when we use the idea of standardizing and automating at the same time. We have many elements that create friction with the main consumer protection measures. For example, the first one is, as you mentioned, understanding from the perspective of the consumer what is indeed the legal obligation, contractual obligation coming from the contract. So to which extent we need smart contract formulated as well in natural language. This is, for example, one of the proposals of the ELI principle on smart contract and blockchain, that smart contracts are always linked to a version in the natural language. It's okay, but it's creating additional cost. What is the purpose? The second possibility is an explanation. So the smart contract has a very short summarized explanation of what is the smart contract about. And the third point is, as you mentioned before, in most of the cases, we are going to be in adhesion contract, in contract of adhesion. We are going to be in contract of adhesion with general contractual terms, standard terms, so we have to apply. all the elements that we already have in private law for the purpose of ensuring opportunity to review, to apply the incorporation contract control, and to ensure that they are not unfair terms as well. So this idea of the smart contract is not isolated, cannot be understood isolated, has to be inserted in all the legal system, as you can see, applicable to either contract or consumer contract or a smart contract in general. Thank you very much for the
Thank you.
Thank you. Okay, so you have 1, 2, 3 more. I don't know who was first. You were first, and then Wolfgang Kerber.
Zenon Zenkovic, I have a question for Professor Schulte-Nolte, and I would like to somehow put inside out the question of justum pretium, in the sense that you were talking of what is the price of data, but when we look at contracts, and been mentioned these so-called smart contracts, but anyhow, what happens? You are very rich, I'm much less rich than you. We go on the internet the same moment, booking for a flight for wherever we go. And we find on the same plane, same flight, we'll find different prices. I will be, as the system knows that I have much less possibility, I will have a lower price, I'll be offered a ticket for a lower price, and you instead will be, as you know, a big spender, you will be offered, and it makes no difference. I mean, 50 euros for you is nothing. I will probably give up, or I'll go on Wizz Air or some other low-cost airline. So the problem, the question is, data influences the price of a final product or service. So doesn't that have a certain value? What is your point of view? Don't you think that this data, the fact that I dispose of certain data, you can do it also anonymously. You probably see, if you go anonymously, you probably get a better price than if you are profiled. If you're profiled as a big spender, you will have a higher price. If you put your anonymization, you have. So I just wanted to know, I mean, what is your view of justum pretium with referring to the fact that this data can influence the final price? As we know, pricing in the EU, you pointed out, there's no control, there's no price control, and apart from, internal market and the issues, or some issues of geo-blocking and things like that, but apart from that, you can sell the same toothpaste, you can sell it in Luxembourg, it costs 100, and in Bulgaria it costs 50, for obvious reasons.
Thank you, Vincenzo, for this question. First of all, you helped me to rebut Martin, because you brought an excellent example why data can have a negative value even for the consumer. But second point, the discussion on personalized pricing is now, I think, 15 or so years old, between a claim for prohibition, between consideration whether it's an unfair commercial practice or whether it's good business. All positions are perfectly legitimate until now, I have the feeling. And as long as we don't have a general price control like lesio enormis, and as long as this is not prohibited, I would consider this simply outside of judicial control. That's a question, it's a political question whether states or the EU wants to allow, to restrict, or even to prohibit personalized pricing. Therefore, I don't care, I must say. Until now, I would say there is no general justum pretium rule. It's perhaps even just that I pay more. Of course, it's a very theoretical example. But therefore, I have no problem. In the liberal market economy, as long as this is allowed, there is nothing. As long as it is clear, if these prices come as part of standard terms and they are unclear, then, of course, we more or less are in a different world, and we are in the complex world. What happens to intransparent price terms? I will not go into this. Therefore, I like your example for many reasons, but it's also, at least in my perspective, a part of freedom. Why shouldn't I pay more if I were so rich?
Sir rebuttal. Just a question. Doesn't 22 of GDPR prohibit exactly that behavior without making it transparent? Having an automated decision based on profiling, that's exactly the scope of application of 22. So you have to lay it open. So when I book my Lufthansa flight instead of my secretary, and mine is more expensive, and they do not lay open, they are illegal. So what are my remedies? Unjustified enrichment?
First of all, I don't know how strict are the transparency requirements under 22 GDPR, but imagine for a moment that they are met. No, you don't need consent for personal privacy. You simply need transparency for its automatic decision making. As far as I know, we should look up. But for the moment, if it's transparent, if all public law requirements are met, including whatever unfair competition law, and then it's fine. It's a question of state policy whether to allow this kind of business or not. It's not for the judges under general private law to deal with that, as long there is no regulatory private law, more or less coming from certain policies that prohibit it.
Discriminatory against the people, wealthy people.
Yes, of course. Yeah, of course. That's precisely what happens in every shop if I have my tie, if I wear my tie.
If I may, I think that we have here three different situations. The first one is that by providing data, this data has a value that could be either positive, as Vincenzo mentioned, either positive or negative, in the sense that either means that I'm going to have a reduction in the price or I'm going to have a higher price. So we're talking about providing data, and therefore the data itself has a value, and this value is indeed quantified in the final price that I pay for the service. This is one situation. The second situation is that the data that is collected, or I provide, is going to be the evidence for the provider to apply a specific criteria in determining the price. So there are already a contractual condition that is said the price is going to depend upon the age of the passenger. And therefore the data that you are provider is just used for the purpose of giving proof that what is your age, therefore I know what is going to be the price criteria that I'm going to apply. This is, in my opinion, a completely different scenario than the first one. And then we have the third scenario, that is, as Martin mentioned, is Article 22 of the GDPR, where the problem is essentially that it is an exclusively automated decision-making that is going to have a contractual impact. So here we have two elements, that is profiling and exclusively automated. So in my opinion, there are three different levels. The first one is purely the value of data. The second is more related to what could be the condition for the purpose of determining pricing in a particular service provider, service provision. Yep. Sorry.
That's fine, thank you. Okay.
Yeah. Many thanks for this very informative presentation. So I think I really have to read it for understanding all of what you've said. I have a specific question to Martin Schmidt-Kessel. And you mentioned quite interesting about the relationship between the data holder and the consumer. And you framed it in a way that there is a duty of the data holder to act in the interest of the consumer. And I found this very interesting because this is not the usual way how the discussion is. And now, if you look from the final version of the Data Act, I think there are now good reasons to really make the argument that the Data Act has assigned the bundle of rights on these data really to the users. And therefore, and the data holder, yeah, what is a data holder then? Yeah, and then I think your notion of that the data holder
is a service provider who is providing a service to the user, I think fits quite well. And if you think that the consumer might be the weaker party, something like that, then also I can imagine that you can make exactly this argument that this is this kind of relationship. My question is, can you imagine also as a further step of exactly this idea that the user, the consumer, should also have a say in the decision who is a data holder? Because the data holder, as you said, is an agent for the user as a principal, and usually principals can decide who the agent is. But this is exactly what is not possible according to the Data Act, which I think is perhaps a problem.
Thank you.
Yeah, thank you.
Sure, go ahead. Yeah, answer.
Yeah, okay. Thank you for that very tricky question. It is tricky because it's quite clear that in the usual process addressed by the Data Act, the data holder is chosen by someone on the seller's side, just to put it shortly, not to have the other types of contract in it. That is part of the offer to sell, probably not of the supermarket where I buy my smart coffee machine, but by the producer or the general, or the quasi-producer, to use the category of product liability. In that sense, we could come into situations where certain providers will be excluded due to lack of quality. But the general, the factual rule will for a long time be it is opted for by the seller. A different question is, what happens if there is a kind of lock-in effect? Should it be free to change the data holder? And I think that's exactly one of the purposes of the Data Act, also in those cases of IoT devices, to change the supplier of the digital service. And that's where that autonomy also comes in. So Article 5 could be perfectly made for exactly that use. Is perfectly made for exactly that use, for changing the service provider. And we have lots of those rules. We have been a rising number of use of changing providers' provisions, so lots of new provisions of what is happening then. And I think this is part of that. It's not only 20 GDPR. We also have here the possibility to use the Data Act to change the service provider.
So we have two
if
direct
there is a competitor, obviously, yeah?
So,
yeah, I think it's a very interesting point, but I was wondering, definitely, I agree with Martin that, sorry about that. I agree completely with the idea of the possibility of the market discriminating which is going to be the service provider that is more reliable or less, and therefore this idea of the consumer deciding. But for the data holder, if we think that the data holder is, for example, the manufacturer of the product, maybe in that regard, do you think that this idea of changing the data holder is it still feasible in the market? Because I can imagine Nespresso providing a smart coffee maker, and in relation to the main data that the coffee maker is collecting, probably is going to be Nespresso. And if I want to change Nespresso from Nespresso to Krups, I'm going to change the coffee maker. I can definitely go to the second step and change service providers that provide apps for the coffee maker. So what do you think, Martin? Because in my opinion, the first one, the data holder, probably is more rigid, and maybe there are more competition in the second layer.
I first see the interest of the producer to create lock-in effects here. That's clear. the clear point. And with the Nespresso situation, we have the point that the product which comes out of the coffee machine is predefined in that very case. So we have no variance for which the buyer of such a coffee machine has an interest to establish a kind of data relationship to the producer. Why should we do that? It's a different thing where we have a coffee machine where we could change the quality of the coffee, yeah? And where we could use a kind of electronic device usually offered by the coffee machine producer to make an optimization, to fix the optimal kind of coffee. So when I come into the institute in the morning, I need a strong one, and after lunch, a not so strong one, in the evening, the weakest one. So we could do that, and also, and there, why shouldn't I use a different app provider for doing that? So I'm there really changing the use of the coffee machine. By the way, if you want to look at it, we are starting a project on that. We have the website on www.kaffeemaschine.uni-bayreuth.de. So, but that's it. I think it is, there are cases where it is realistic. And also in the car case, to which garage I'm bringing my car? I try to avoid the typical offerers from the large producers and to have a private one instead. So
I just wonder whether we do not have some special legal regime for that in the next chapter. That would be your intervention. Sorry about that. Didn't take your point. Thank you. Okay.
It is such a service and not only a data holder in the classical sense.
Yeah, that brings us to your point that we have kind of mixed type contracts, that there is no longer a simple sales contract for any IoT device. It's always a mixed contract. Yeah, so you're waiting for quite too long. Sorry, but
no, it's okay. It was, in any case, a very interesting discussion. I'll try to be brief, but I'm going back in a way to the fundamental question of value of data, and perhaps, and I'm looking at this in a pretty general way. Perhaps the question of whether is there value, how much value should accrue to the consumer or to the individual who is the initial originator of the data. It's an important question, but perhaps we should have a slightly broader perspective, because perhaps there's no single value. There is value, the question is value to whom and under which circumstances value is produced. And in many of these cases, the value, in some of these cases, the problem, and that is what makes these things particularly problematic, is that the consequences in terms of value production are sometimes good for the originator of the data and sometimes not so good. And that is what makes this an interesting question also from a theoretical point of view. And not just simply lawyers, but economists are thinking about this really in a massive way. And let's think of a relatively simple case of data coming from a smart car. I mean, some of these data going to the manufacturer is good for the buyer of the car, for the consumer, because it allows to improve elements in the software that is going to make your driving easier, more adapted to the circumstances, safer for you and for others, so that's good for you. On the other side, for instance, the value of your of your driving data in isolation for the car industry in order to make better cars in general is zero, because your individual data are worth exactly zero for the car industry. But if your data is combined with data from millions of other drivers driving hundreds and thousands of kilometers, that is extremely valuable for the car industry in general. But just one piece of data is worthless. On the other side, data may be worth for your insurance company or the financier who has give you a leasing contract on your car, but that is again something that has to do with, it's not so much your individual data, is that if an insurance company or a financial company has data on relevant characteristics for the risk and the cost to them of serving a particular client, this is valuable. But not in your particular case. Again, it needs to be combined with lots of other data. And obviously, we also have this use of data to simply increase your prices or personalize prices. And that is the classical, many people think of that as the only source of value, which is definitely bad for the consumer because it's essentially meaning that perhaps your prices, or at least the surplus from each and every single transaction you're going to enter into, is probably to be lower than without data on your prior behavior, on your preferences, and so on. So the question is, I mean, it depends. It depends on value for whom, and depends on value under which circumstance. Sometimes the value is zero for some people. Sometimes the value is huge for other people. Sometimes that value is reflected back on the originator or the data subject. Sometimes it's not. And I think it's really hard to give very general guidelines on this. And just a very tiny thing, I always thought that personalized prices were clearly legal on the face of Article 6EA of the Consumer Rights Directive. It says, well, you have to inform of personalized prices on the basis of an automated process. If it's illegal, how can you inform that something illegal is being practiced upon you? I think it's clear that it's, at least to me, in a very simple interpretation of the Consumer Rights Directive, that if information requirements are satisfied, there's nothing wrong from EU law, from an EU law perspective, which perhaps is a bad idea, but it's beyond the current state of EU law, I would say.
And to your last remark, as far as I know, the Unfair Commercial Practices Directive does not say anything on the question whether it's allowed or not, as long as there is leeway for member states to prohibit practices. For example, selling under price is prohibited in some countries, and therefore it is not touched by this directive. But on value, you're of course perfectly right. Value for whom may end up with very different positive or negative figures. My favorite example is not consumer data, it's the agricultural data on soil. They may be very valuable for the seller because the seller knows whether better to disclose or not, or to sell a lemon, and they may be also very valuable for a buyer. That's positive or negative. That's pretty clear. However, there's always a third person for whom data is certainly very valuable. Imagine a third person, whatever, the producer of the smart tractor who has this. For him, the data is always valuable. It is more or less the value, well, which corresponds to the removal of the uncertainty of the quality of the soil. That's pretty clear. And the question in all our data law considerations is, should the first and the second person, meaning the seller or the buyer, be entitled to participate in that value or perhaps even get the value at all? That's precisely the question we are dealing with. Data is always or nearly always for someone valuable, and this person wants to have a silo, and the Data Act deals with the question whether others, for example, in our case, the user of the smart tractor, should be entitled to access to this data, and this answer is yes under the Data Act. And that's new, that's totally new. This opens up a silo and of course also somehow takes away the value from the manufacturer. The manufacturer must change their business models insofar.
And if I may, following this general approach that Fernando was suggesting about value, value could be even interpreted in different ways. The first one is value is utility, so it's useful. As Hans was referring to different situations where it's useful for different parties involved. Value in the sense that has a price, because there is a value, has a price, that I'm willing to pay a price for that. Or also value can be compensated in case of loss, for example. And that is, in my opinion, a very significant addition in the revision of the defective product liability. Because of the defect, data are lost, and I have to compensate the lost. So that we need to value, to provide indeed an amount for purpose of the compensation. And then there is another perspective that probably we assume naturally, but in my opinion it's interesting to make this distinction. If I have the data about my driving are used by the insurance for the purpose of reducing the premium, we are making a distinction between the value of the data, that as you mentioned, and I completely agree with you, that for the purpose of improving the safety of the cars is irrelevant, but the consequences of making this data available to the insurance company are positive in this regard. So for me, it's valuable to the extent that my driving data are going to entail a reduction in the premium of the insurance. So for me, value, and I completely just elaborating on your point, the idea of value is so polyphacetic that we need to take into account all these elements. Contract law is just thinking about one of the perspectives, in my opinion, that is very much related to value to be transferred by way of contract. Thank you.
Thank you. And since I see no more questions, it's quite interesting. But one final remark from me that we are now back to this, let's say, starting problem of the whole data economy, that we talk about the use of information, and it brings us back to the decades of information economics. Just like that, where we can have loads of more conferences. But I stop here. I say a big thank you to all three speakers, to the audience for discussing with us, and I think for today, we have successfully finished the first half of the conference. Alberto, would you like to say something? No. So we see each other tomorrow at 9. Thank you very much. To all the speakers among us,